Good morning. Good morning. Can I ask you all to take your seats? Thank you very much. Good morning. You're all very welcome. My name is Siobhan Mullally. I'm Director of the Irish Centre for Human Rights, and we're absolutely delighted to welcome you here this morning. President, Deputy Secretary General Berge, Excellencies, distinguished delegates, colleagues, friends. On behalf of the Irish Centre for Human Rights, I'm delighted to welcome you here today for this important conference, and welcome to all of you who are joining us online also. The conference today addresses the issue Lighting the Shade, effective application of the European Convention on Human Rights in areas of conflict in Europe. It's a great honour for us to host today's event, organised during Ireland's presidency of the Council of Europe, and coming at perhaps one of the most challenging moments in the history of the Council of Europe. Against the background of the armed attack on Ukraine by the Russian Federation in violation of international law, the expulsion of the Russian Federation from the Council of Europe, a climate emergency, growing inequalities, and we see the persistence of threats to the protection of human rights, to the enjoyment and realization of human rights, and the promise of peace and democracy here in Europe. It may be timely also to recall the words of the Irish poet Nuala Ní Dhomhnaill. Her poem Duv Hittim Srebrenica, a black day this on the fall of Srebrenica, 11th of July 1995. Is lo duv éisio, ton spéir duv, ton orga duv, ton a gardini duv, ton a queen duv, ton a cnic duv. It's a black day, the sky is black, the sea is black, the gardens are black, the trees are black, the hills are black, a dark day. At the same time, and I think the purpose of today's event and the title itself brings it to us, Lighting the Shade. We think about the potential of the European Convention on Human Rights, the hopes and aspirations that went into the founding of the Council of Europe. And as one of the original signatories of the Statute of the Council of Europe, Ireland is now at a pivotal time holding the presidency of the Council, at a time of great uncertainty for the future of our fragile system of human rights protection that is founded upon the European Convention on Human Rights. And as one of the original members of the Council of Europe, Ireland played a pivotal role in the negotiation and conclusion of the European Convention on Human Rights. Sean McBride, the former Minister for External Affairs, on the adoption of the Convention, commented that it would be a real instrument of cooperation and not merely a facade that was being created. A Convention on Human Rights, he said, which did not grant any right of redress to individuals, was not worth the paper it was written upon. And Ireland, of course, was and has been at the heart of many landmark cases before the European Court of Human Rights. The first judgment of the court, Lawless in Ireland, the first interstate case, Ireland versus the UK, critical cases on gender equality, women's rights, Norris in Ireland, Airy in Ireland, ABC versus Ireland, O'Keefe in Ireland. We are keenly aware of the everyday harms of human rights violations, of failures of protection, and of the aspirations and relentless struggles of those appealing to the promise of international law and its institutions. René Cassin, then president of the court, in his final statement in Lawless in Ireland, said the court exists only to serve the cause of justice. Media reports on the case, the Irish Times, 3rd of July 1961, no violation of human rights in the Lawless case. In the Irish Independent, Lawless loses case. But the Council of Europe, Directorate of Information, in a note in August 1961, comments, the right of inquiry into the internal affairs of a state, forbidden by the Charter of the UN, has been shown to be possible amongst the like-minded nations of free Europe by virtue of the Human Rights Court. Of course, we know that the promise of universality is always contingent, limited, not yet realised. The European Convention on Human Rights was drafted at a time when many of the member states of the Council of Europe were still colonial rulers against a background of empire, racism and imperialism. Yet the Convention and the Universal Declaration on Human Rights, which it builds upon, present a normative claim, an aspiration, one that we seek to realise that rights would be not merely theoretical and illusory, to paraphrase the court, but practical and effective. Rights feel so powerful in the mouths of those who have been denied the enjoyment of rights. So the purpose of today's event is to continue to work towards the ideals of human rights protection, of the universality of human rights mostly denied, and in doing this work to place the holder of rights, the subject of rights, at the heart of our work in seeking to realise human rights protection effectively. I want to take the opportunity to thank Dr. Andrew Ford, a visiting fellow here at the Irish Centre for Human Rights, and we're very proud to say that he's an alum, both of our LLM and PhD programs. He is the energy, the vision, and the very hard work behind the organisation of the conference. Thank you to the Department of Foreign Affairs for the support that they have provided to this event. And I should note that this is an academic event. It's an opportunity to bring together academics, practitioners, civil society, diplomats, organised as such as part of a university event to reflect and think upon the future of the Council of Europe and the European Convention on Human Rights. Thank you to the many speakers and delegates who have travelled here to join us. And I would also like just this morning to remember our colleague and friend, James Kingston, legal advisor to the Department of Foreign Affairs, who was part of the early discussions on the organisation of the conference. And James, as you know, was always committed to bringing together academics, practitioners, diplomats. He would have enjoyed being part of us, questioning, reflecting upon the European Convention on Human Rights and the ideals of international law, and the radical promise of universality. James worked, as you know, as a legal advisor, an active participant in many critical discussions on public international law at the Council of Europe. And I'm sure he will be watching over us today. So to open the conference now, I welcome Professor Ciaráin Hogartig, President of the University of Galway. Thanks.
Thank you, Siobhan, and thank you very much, Sean Fáilteoirí Imagine. Agus tamid ana weekly was fechen Sean Aliv Ling. This, as some of you may know, is a day when we're changing the name of the university from NUI Galway to the University of Galway. So this, in fact, is the last event which will be held in the auspices of NUI Galway and the first event to be held in the University of Galway. So we're very pleased for that. And because of that, unfortunately, I can't stay. We have the Minister visiting. We have radio interviews and so on around 9:30 or so. So I'd love to stay because it's a really important event for us here. Particularly like to welcome a number of visitors. I'd like to welcome you all, first of all, because it's really important to us that Galway is a venue for a conversation such as this. Academic, open discussion on areas of importance and real importance in the world as we have it today, as Siobhan has mentioned. But I'd particularly like to welcome Bjorn Berge, the Deputy Secretary General of the Council of Europe, Maeve Collins, the Director General of the Department of Foreign Affairs, Gressa Chakanimani, who I understand is joining later as President of the Constitutional Court of Kosovo, Nina Liomaria, who's the Public Defender of Georgia, and Senator Claude Kern as well. All welcome here, but you're all welcome to Fáilteoirí Imagine. We say in Ireland that there are no strangers, just friends we haven't yet met. And I think that's important for us here too. This particular event is really important as part of the values of this university. We have, when we developed our strategy, and Siobhan was involved in the committee which developed it a number of years ago, we developed a strategy which we said was values-based, and that the university would be driven, would be coalescing around a series of values. And this conference is a particular articulation of those values, because the most important of those values is respect. And we had Patricia King, who's the President of the Council of Trade Unions in Ireland, on our strategic group, which helped us fashion the values. And she said, if there is respect, all else follows. And if you only had one word over the archway, and that was respect, that would make a big difference. And I think in particular, I think the focus today on a systemic rights holder approach to human rights and to the particular issues that in debate is particularly important in that context. And the respect that's at the core of that, particularly important to us. The second value we had, and particularly we're very aware of this in the context of conferences generally, the value of openness. And we have open debate, as I said today, but particularly what we're keen on in that context is openness to different and diverse voices. And as a university, we're very keen to open up to those wider debates, those critiques in society, that very often voices of dissent, which can be difficult at times, but also are those that make a difference. But the second aspect we're particularly keen on is dialogue between policymakers, academics, society at large, and civic society more generally. And again, this conference is an articulation of that very nicely, bridging that sense that we have between academic debate, policy, both policy formation and implementation. And we're particularly keen to welcome you for that reason. And then the third value we coalesced around was the value of excellence, high standards. And we think there's never a contradiction between high standards and respect. If we work with respect for others, we do our best work for them. And again, I'm particularly pleased that today we have some excellent speakers, excellent academic work, particularly here in the Irish Centre for Human Rights. We're very proud of the work that the Centre does in the area of human rights with an international reputation beyond Galway. And one of the things we'll be saying this morning about being in Galway and what will be the University of Galway is that we always look beyond the horizon. We sell our region short if we have only a local perspective. And I think the Irish Centre for Human Rights and Siobhan and her colleagues are particularly to the fore in looking beyond the horizon and looking at policy challenges, human rights challenges beyond that horizon. I'm particularly pleased and welcome the Council of Europe's approach in this regard and the academic work being done, the Oceans programme, which I understand Andrew is involved in, and other colleagues in the Irish Centre for Human Rights. So again, commend the work of the Council of Europe in this area, because the intersection between academic work and research and evidence and policy making is more important than ever. We know that good evidence leads to good policy making, and that evidence very often now is the truth, if you like, or reality is sometimes under threat. And we know now more than ever the importance of good research and good academic evidence, excellence in the university community in developing good and strong policies. And finally, and sometimes this is a bit tangential, but the final value that we coalesced around was sustainability. And that was particularly our students asked us, as you might understand, to have a focus on sustainability. And we're particularly pleased this year that we were ranked in the top 50 in the world in the Times Higher for impact in the context of the Sustainable Development Goals, #1 in Ireland. So that environmental element of sustainability is particularly important to us. But I think events such as this are also important for sustaining a debate, sustaining a new generation of research, sustaining policy making, and sustaining each other, because very often during COVID we didn't find that opportunity to come together as a community of academics, practitioners, policymakers, in order to debate events, areas such as this, important areas such as this. But also, most importantly, we didn't find the time and the opportunity to come together to support each other. And very often work in this area can be very challenging, very difficult, and I think together as a community we face them better than alone. And seminars, conferences such as this plays a very important role in that regard. So particularly pleased for those reasons to welcome you here, that you are consistent, you are articulating the values of NUI Galway as it is, at this moment, University of Galway as it will be, because the final thing I'd say, which we committed to upfront in our strategy, and it was something that we debated and we thought sometimes should go without saying, but often doesn't, is that we are a university for the public good. And that means that we don't serve ourselves, we serve each other, but most of all, we serve the society at large, the public good more generally. And very often universities don't say that and make that point often enough, that universities are places for the public good, which have debate, robust debates such as you'll have today, but debate also which hopefully makes a difference and leads to action and leads to a better world. The responsibility of us all to leave the world in a better place than we found it. So gur míle maith agah, tá mí don a bhuaictí bhás bheithin seo, agus guim gach rathaíh agus tá brona nach féidir an fánaigh níos faide. I'm sorry I can't stay longer, but you'll understand that the day will pass and you'll have come to NUI Galway and be leaving University of Galway. Gur míle agah. Thank you.
We now have 2 short video addresses. We're going to change the orders slightly and take, first of all, the opening remarks from Deputy Thomas Byrne, Minister of State for European Affairs, who's addressing us via video link. Thank you.
Dear friends, allow me to extend to you a virtual Céad Míle Fáilte, 100,000 welcomes to Galway, Galway. I do wish I could be there in person with you, as I know does Minister Coveney. But while other government demands prevent our presence, I'm pleased to be joined by my friend, Deputy Secretary General Bjorn Berre, in opening today's discussions, and to thank all of you who are contributing to them. It's fitting that a conference on the Council of Europe should convene in Galway, for this, in many respects, is the most European of Irish cities, a European capital of culture. It was Ireland's medieval gateway to maritime Europe. And along Ireland's western edge, no forum is better placed to host such a conference than the Irish Centre for Human Rights. For almost 25 years, it has been amongst the preeminent academic houses for human rights research on this continent. And under the stewardship of Professor Siobhan Mullally, its work has never been more vital. Like Galway, the European Convention on Human Rights holds a special place in Ireland's European story. In 1949, Ireland was a founding member of the Council of Europe, and a year later, we were one of the original signatories to the Convention. The very first decision made by the European Court of Human Rights concerned an application against Ireland. So we were the first state to accept the court's jurisdiction as binding. And in the decades since, we've seen its rulings serve as a catalyst for positive social change within our country. Today, as Presidency of the Committee of Ministers, Ireland is a proud custodian of all the Court and Convention, what they stand for. Supporting their effective functioning across Europe is one of the priorities of our 6-month term and one of the reasons we so welcome this conference. Our Uachtaráin, our President, Michael D. Higgins, who is an adjunct professor of this centre, has described the Council as the conscience of Europe. In times of conflict, perhaps, it's then that our conscience can be most sorely tested and badly needed. Ireland has experience to attest to this. Through the Troubles, our island has known what it is to suffer protracted conflict, and in the Good Friday Agreement, which was adopted not long before this centre was founded, we've known also the privilege of a hard-won peace. The European Convention on Human Rights was no small part of this. Its full incorporation into Northern Ireland law was and remains integral to the Good Friday Agreement. It has helped to build and maintain confidence in Northern Ireland's political, policing and judicial structures, protecting the human rights of all communities. The agreement, of course, was the result of a long negotiation and difficult compromises. As Senator George Mitchell recalled, Good Friday was one day of success following 700 days of failure. Alongside remarkable patience, the agreement demanded profound political courage from parties to the negotiations. 2 men who've recently died epitomised those qualities. I've often spoken of the great John Hume, who frequented Strasbourg as a member of the European Parliament. He championed the role of the Convention in the Good Friday Agreement. But I want to recall his fellow Nobel laureate David Trimble, who passed away just over a month ago today. Delivering his Nobel lecture alongside John Hume, David Trimble observed that the dark shadow we seem to see in the distance is not really a mountain ahead, but the shadow of the mountain behind, a shadow from the past thrown forward into our future. The goal of today's conference, as Dr. Andrew Ford has framed it, is to reflect on how we might light the shade, how we can ensure the full protections the Convention affords that they're shared across this continent, above all in areas of conflict. In this task, we could do well to recall David Trimble's words, recognising that we must engage honestly with our history, but that we cannot allow our futures to be prisoners of our pasts. A chóide, dear friends, it was on Ireland's initiative in 1949 that the Council of Europe committed itself to the pursuit of peace. And it's that pursuit of peace and accountability for its violation that occupies our minds today. The Russian Federation's unprovoked invasion of Ukraine 6 months ago has underscored just how vital the Council's standards are and just how much protection they need. The violations of human rights and international humanitarian law perpetrated by Russian forces are, as Commissioner Mitrovic noted, staggering. How can we respond to those outrages is a test to the credibility of the Council of Europe, and the result will resonate far beyond Ukraine and far beyond this time. Determining how the Convention and the rights it enshrines are viewed and applied across other conflicts for years to come. Since February, Ireland has welcomed over 50,000 Ukrainians to our shores. It's one of the highest per capita in the EU. As Presidency of the Committee of Ministers, our highest priority has been to address their nation's plight. So, to that end, we've strongly backed Secretary-General Burridge's revised action plan for Ukraine and invested significantly in it. We've fast-tracked Ukraine's admission to the Council's Development Bank, establishing a new donor fund to aid those who are displaced by war. And we're working in Strasbourg, just like New York, Geneva and The Hague, to ensure accountability for the crimes perpetrated on Ukrainian soil. In all of this, our first and most essential goal has been to help a fellow Council of Europe member and her people. But we're investing also in the future of the Council of Europe system and in the values it underpins across our continent. So today's conference is part of that work, part of that investment. Building on reflections on interstate cases organised under last year's German presidency, it addresses a key challenge facing the Council, which is how to leverage the full range of the institution's tools to reinforce the Convention where it currently is most curtailed. This is a challenge of first principles. The protection the Council system provides should be available to all Europeans. We all recognise the sensitive political issues at play, but by design, I know this conference is not a platform to pronounce on status. Rather, it's an occasion to consider standards and systems and how we can maximise their effectiveness. Supported by our presidency, that this conference is today, it has been independently organised by the Centre and above all by Dr. Ford. It is innovative in focus and design, and as the high-level group our former President Mary Robinson chairs reflects on the Council's future, it's very timely. Importantly, it's inclusive, drawing on expertise from across Europe and the breadth of the Council's core institutions. In this approach, it reflects the wisdom of one of the Seanachal, a proverb for which Galway is renowned, Ní neart go cur le chéile, which means we are stronger together. Let me end on that thought. I wish you a stimulating and successful discussion today. I hope that through your efforts, even as summer ends and the days begin to darken, we might find new ways of casting light across this continent. Gur míle maith go léir.
Thank you very much. Important words there on the purpose of the conference and the themes of the conference, the theme of inclusion and belonging, I think. We can also quote, as Mary Robinson has often done, the Ulster poet Louis MacNeice, pride in your history is pride in taking your own pulse and counting in you someone else. The idea of belonging, inclusion, multilateralism, diversity within. As one of the goals of the Council of Europe in promoting peace, democracy and human rights. So we're going to move now to our second video address from Mary Robinson, former President of Ireland, former UN High Commissioner for Human Rights, Chair of the High-Level Reflection Group to advise on the future role of the Council of Europe. We're delighted also to host the Mary Robinson Archive here at the university. She has sent the message because she is at the moment with the elders in Uganda. So we'll move now to her message. Thank you.
I'm very pleased to address this timely conference on such an important theme, and especially pleased that the conference has been organised by the Irish Centre for Human Rights under the auspices of the University of Galway. Lighting the shade is an appropriate metaphor for protecting the rights of those who live in the shadows because of political circumstances beyond their control. This is a conference about protecting the rights of the inaccessible, the vulnerable, and the forgotten. Its focus is on how this can be done better. Hopefully, you'll be much better equipped to give some answers to this interrogation as the light fades in Galway this evening on a day punctuated by insights and inspiration. As you all know, the problem with the shade is that it provides cover for often egregious human rights violations, compounded by a total lack of accountability. It's a frequently observed paradox of international human rights law that it often lacks effectiveness in areas where it's needed most. In situations of national emergency, for example, where judicial responses come many years after the event, if indeed at all. And in times of war, when principles of basic humanitarian law are invariably cast aside with impunity, and in areas where conflicts have frozen or been left unresolved, the so-called grey zones or legal vacuums, opening up a series of black holes that defy the probing light of accountability. In these areas, the press is frequently muzzled to ensure that light doesn't escape to bring attention to what is going on, and where legal remedies are the inevitable casualty of the suppression of the rule of law. There may even be fabricated patina of democracy to pay lip service to the concerns of the international community, but underneath there is likely to be just an empty shell from which the rule of law has been scooped out and eviscerated. Many complex legal issues also arise. What principles govern the extraterritorial reach of human rights treaties? What are the human rights obligations of the states involved in disputed territories? Is there scope for non-judicial mechanisms to promote and protect rights in these zones? And of course, it's in these zones of darkness that key judgments of the European Court of Human Rights are not likely to be enforced. The court, as we know, is necessarily limited in what it can achieve through its judgments concerning these areas. It has interpreted the notion of jurisdiction creatively to ensure that the rights and freedoms of the convention remain relevant. For example, in Transnistria and in Nagorno-Karabakh, not to mention military operations abroad. It has courageously based itself on the dictum that international human rights law doesn't like a vacuum. Yet many of these key cases are not enforced by the respondent states because of a certain inertia or sentiment of perceived helplessness or futility that limits the action of the Committee of Ministers. In other words, our institutions have developed over the years an unfortunate tendency to acquiesce in situations whose very abnormality demands a much sterner and more hard-headed response. The time has come, it has undoubtedly come, for the development of new approaches. And I have little doubt that many creative solutions will be, suggestions will be made in today's discussions. There's certainly a good case, as I've already hinted, for rethinking the role of the enforcement procedures before the Committee of Ministers to make them more insistent when faced with brazen non-compliance and more resistant to the creeping ethos of powerlessness when confronted with delinquent behaviour. Simply put, more needs to be done despite the inherent difficulties. And one simple thing would be if the Committee of Ministers brought together more ministers. My understanding is it's often the ambassador who doesn't feel motivated or doesn't feel empowered to take a political stance. So Can we ensure that the Committee of Ministers has ministers at the table when necessary? For we are all witness to the calamities and catastrophes that can occur when Europe stands back and tolerates the persistent thwarting of the rule of law. There's always a price to pay at some stage for allowing dark areas to develop inside the territories covered by our treaty arrangements. It seems to me that in such zones that are now within the pale of the Convention, but in reality outside its effective embrace, there's more scope for immediate action by monitoring bodies such as the CPT and the CPT and the Council of Europe's Commissioner for Human Rights, both of whom have understood that inaction is not an option compatible with European values, and they've carried out visits in such territories in situations fraught with political and diplomatic difficulties in order to perform their vital missions. Their terms of reference give them a much greater degree of flexibility than lengthy and uncertain judicial procedures. The multi-pronged fact-gathering capacities of the Council of Europe's monitoring bodies, including national offices, can be harnessed with even greater effect to harvest vital information concerning the protection of human rights on the ground in these areas, to be channeled in a timely manner to the Council of Ministers, to the Parliamentary Assembly, to PACE, and the Office of the Secretary-General, in order to shed light on the human rights problems on the ground and assist in the formulation of policy. I ask the question, is there not a case to be made for creating an office under the control of the Secretary-General or the Assembly or the Committee of Ministers, whose task is to keep the institutions au fait, aware of, au fait with human rights issues in these areas? Or are present arrangements considered to be sufficient? Does the plight of the second and third class citizens who inhabit these areas not merit some degree of special attention? Undoubtedly, monitoring bodies such as the CPT and the Commissioner and others have a crucial role to play and need greater practical and political support to perform their role. To ensure that they have proper accessibility to regions, even those that may have recently fallen outside their remit, should this be possible. So, dear friends, this is a difficult time to talk about human rights when a brutal, aggressive war against Ukraine is being waged today on Europe's doorstep. Yet it's certainly the right time, because history shows us that difficult times can be a catalyst for important change. European states and all their institutions working in concert need to come together as a whole to assert their values vociferously and develop new approaches to these problems, and perhaps new methods and agencies to assist in their resolution. It's no time for technical quibbles about whether and how the EU should become a party to the convention system. This issue has already been decided. What is needed is the political will to follow it through. And why not a member state of the Council of Europe at the same time? It's in the very nature of such problems that they can only be overcome by the combined skills and expertise of the European Union and the Council of Europe functioning together as closely as possible, nothing less. We mustn't overlook that it was out of the maelstrom of recent European history that the Convention was brought into being. And it is ultimately the legacy of the Convention that should spur us into action in ensuring that human rights accountability is brought to bear in areas of frozen conflicts in the most creative and imaginative manner possible, with proper political support and harnessing all of the synergies at our disposal. It's not right that the human beings who live and suffer in such zones be deprived of remedies and the public concern that they well deserve. So, friends, the concluding words of Amanda Gorman's acclaimed poem, The Hill We Climb, provide a fitting end to my own remarks and strike the right note for what lies ahead. When day comes, we step out of the shade, aflame and unafraid. The new day blooms as we free it, for there is always light. if only we're brave enough to see it, if only we're brave enough to be it. So I wish you every success with this important conference. I wish I could be with you, but I'm going to be in Uganda for the elders, and all the best to all of you, and best wishes. Thank you.
Thank you very much. I think a lot there to discuss throughout the day on the new approaches and very concrete proposals for ideas that we might discuss throughout today's proceedings. I'm going to move now to welcome Mr. Bjorn Bjerge, who's Deputy Secretary General of the Council of Europe since March 2021. We're delighted to welcome you to Galway. The Deputy Secretary General is involved in a number of key areas of work within the Council of Europe, most importantly for us today, in advising and overseeing the implementation of the Secretary General's reform agenda in line with the decisions and priorities of the Committee of Ministers. He was previously has a distinguished record in diplomacy and multilateralism, including within the Council of Europe, before taking up this post as Director General and Secretary to the Committee of Ministers of the Council of Europe, as Director of the Private Office of the Secretary General and the Deputy Secretary General, which involved preparing, coordinating, implementing comprehensive reforms of the organisation. So we're delighted to hear your thoughts and reflections on the theme of today's event. Welcome. Thank you.
Very good morning to all of you. It's great to be here in Galway and at this very important conference. Professor Mullally, Director of the Irish Centre for Human Rights, distinguished participants, dear friends. And now I'm drinking wine in France, the helpless child of circumstance. Tomorrow will be loud with war. How will I be accounted for? It is too late now to retrieve a fallen dream, too late to grieve. A name unmade, but not too late to thank the gods for what is great. A keen-edged sword, a soldier's heart, is greater than a poet's art. And greater than a poet's fame, a little grave that has no name. These were the telling words of the Irish poet Francis Ledwidge over 100 years ago during the First World War. Often referred to as the Great War, this war was anything but great. What was great, bordering incomprehensible, was the scale of people suffering, the outrageous number of people killed, and the many who suffered injuries that they carried with them throughout the rest of their lives. From Ireland alone, if I'm not mistaken, nearly 37,000 soldiers were killed. Today, Europe is sadly suffering from a major war in the midst of our continent. Some of us thought, maybe naively, that the conquest of other countries by military means was something from the distant past, something that had no place in a developed and modern Europe. Our hope was that through trade, investment, cooperation, we would all gain, Europe would flourish, and that this would be a win-win situation for everyone. Evidently, we were wrong. The old ghosts of previous world wars, of aggressive nationalism flavored with populism, hatred, and manipulation, are again haunting Europe. It is a paradox, in particular for the Council of Europe. Since the two bloody world wars, our organization was established in 1949 to help ensure that such violent political forces should never again dominate European countries, but to no avail, it regretfully seems. The Russian invasion of Ukraine has cast a dark shadow over all of Europe, causing pain and suffering, affecting millions of people. Here, let me quickly add that immediately after the Russian invasion of Ukraine, the Council of Europe and its member states took firm and resolute action. Within 24 hours, the Russian Federation was suspended as a member, and it took only a few more weeks before the Russian Federation was expelled from the organization. The Italian presidency of the Committee of Ministers, the President of the Parliamentary Assembly, and the Secretary General all provided leadership in that process. Today, our thoughts are first and foremost with the brave Ukrainian people and their leaders. But this war affects us all in some way or another. Parts of eastern and southern Ukraine have now been occupied, in addition to the illegal annexation of Crimea in 2014. In a sense, these are not gray zones, but illegally occupied areas that must warrant our concern, including with regard to the human rights situation of the people that live there. More broadly, over the years, if not decades, we as an organization, as well as our member states, have struggled to cope with the failure to fully implement the European Convention on Human Rights in several parts of Europe, whether we call them gray zones, frozen conflicts, or disputed areas. Certainly, ministerial meeting after ministerial meeting has emphasized over and over again the importance of securing access to these areas and of protecting the people who live there, be it in Transnistria, Nagorno-Karabakh, Abkhazia, and South Ossetia, or elsewhere. At the ministerial meeting in Helsinki just 3 years ago, member states underlined that they remain concerned about the unresolved conflicts that still affect certain parts of the continent, putting at risk the security, unity, and democratic stability of member states, and threatening the human rights of populations concerned. But still, very little progress has been achieved. Why is it so? Why is it so complicated? And why is it close to impossible to have any real progress? I will try to point out a few possible considerations that might be relevant in this regard. But let me first of all state what may seem obvious to many, but which, regrettably, not always is evident for all. As parties and member states of the Council of Europe, there is a clear responsibility to ensure that the European Convention on Human Rights and the judgments of the Court are respected and implemented throughout the European continent. This is an undisputable legal obligation, not a kind or gentle request. Which brings me to my first point, political will. The Russian Federation has been and is central to several of Europe's current frozen conflicts. And during its membership in the Council of Europe, it did not play a particularly helpful role when it came to improving the human rights situation, whether in South Ossetia and Abkhazia in Georgia, or Transnistria in Moldova. Following Russia's expulsion from the Council of Europe, and in light of the ongoing war in Ukraine, is it likely that we will see a more constructive and pragmatic Russian role in this regard? Probably not. But this should not be an excuse for us to do less. On the contrary, we should see how we can support Ukraine and other countries directly affected, such as Georgia and the Republic of Moldova, even more. Secondly, it will be a mistake to generalize too much about the various gray zones or frozen conflicts. Each has its own particular and unique characteristics. Equally, all of us here today could probably agree that the populations living in these areas are, as a matter of principle, under the protection of the Convention and our court. But regrettably, our experience is that in nearly all of these areas of conflict, we have far too often seen a deterioration of the human rights situation, including a persistent lack of effective access to our monitoring mechanisms. It remains essential that we are able to be on the ground to observe, assess, and monitor as required and in line with our mandate. Our presence in such situation should never be seen as any form of endorsement of any parties, in particular de facto authorities, but simply the implementation of the Convention to help verify the human rights situation, and in some cases, give a voice to the voiceless. There have, however, been some positive developments. Our Human Rights Commissioner's visits to Abkhazia and South Ossetia, and more recently to Transnistria, were very important. And our Secretary General's consolidated reports on the conflict in Georgia, as well as the human rights situation in Crimea and the city of Sevastopol, serve as a basis for our Committee of Ministers to adopt relevant decisions. Further, and importantly, we have worked on confidence-building measures, CBMs, that help divided communities to come together and build trust through dialogue on issues of common importance. In doing so, they also aim to promote human rights standards in post-conflict or frozen conflict regions, and hopefully can be seen as constructive in paving the way to political progress. A case in point is the meeting that we organized in May between civil society representatives from Armenia and Azerbaijan to discuss peace building and reconciliation in light of a conflict that has affected both countries. This was a good exchange during which participants agreed to continue their dialogue and to work on possible joint initiatives. Other relevant activities include registering attacks on media workers, including in areas of conflict, via the platform to promote the protection of journalism and safety of journalists. And I also want to highlight the importance of the various reports, resolutions, and recommendations by our Parliamentary Assembly. And in particular, the emphasis that it has placed on the presumption of access principle. The principle that our monitoring mechanisms should assume that they have access to all European territories, and that where access is denied, the reasons for that decision must be made explicit to the Committee of Ministers. Overall, all of the things I mentioned above have in some way made a positive difference, and we can build upon it to go even further. And we must, because they still fall short of providing the standard of protection that should be assured in a territory of our member states, something that we are obliged to ensure in the interest of all their people. Thirdly, I must also mention the crucial role of our court, as it deals both with individual cases as well as interstate applications linked to areas of conflict. From these applications, the court has developed case law on the application of the Convention in regions outside the control of the territorial state. These cases certainly involve many complex legal problems, including whether jurisdiction can be presumed and how such a presumption can be rebutted, or for that matter, whether jurisdiction can be limited to certain positive obligations under the Convention, and how the concept of jurisdiction interacts with the notion of accountability and the substantive obligations under the Convention. In some instances, there have been rulings that if one state has effective control or decisive influence over part of another's territory, it is responsible for violations there. Such cases have arisen from situations in northern Cyprus, Transnistria, Nagorno-Karabakh, Abkhazia, and South Ossetia, and other territories. And there are currently many cases concerning Crimea and eastern Ukraine pending before the Strasbourg court. All of these examples do have legal and political significance, but it is important to be clear. The court's process does not imply international recognition of de facto regimes or occupying powers. Fourthly, we must start to put citizens' rights above politics and conflict, as the Convention always intended, and ensure that these rights are a reality for people who live in these territories. Throughout our organization and over the years, we have tried to make a proactive and pragmatic approach to achieving this. But, as I've already stated, it has not been enough. In practical terms, our monitoring activities could be further expanded and replicated where possible, and the role of our Human Rights Commissioner could also be very important. And here, I could also mention that our Steering Committee for Human Rights will present a report to the Committee of Ministers this autumn with proposals on the effective processing and resolution of interstate cases by the court. And at last year's ministerial session in Hamburg, our member states restated the importance of examining how to enhance the committee's tools for supervising cases of non-execution, including the persistent delay to execute the court's final judgment, as well as questions arising from the execution of judgments in cases relating to interstate disputes. Moving forward with these and other measures will, of course, require political will, and ultimately, it is for the member states themselves to help us push for progress. Last but not least, I have no doubt that this issue will be on the radar of our organization's high-level reflection group under the very able leadership of the former President of Ireland, Ms. Mary Robinson, as we just heard. And the group will no doubt reflect on the Council of Europe's future in light of the current political situation in Europe. I also believe that these matters will be relevant for a possible fourth summit of the Council of Europe, heads of state and government. Though its agenda will, of course, be set by the member states themselves, and priorities and action will be theirs to decide. Dear friends, what is certain and unchanging are the words of the European Convention itself. So at this crucial and very challenging moment in European history, where the task of ensuring fundamental rights in areas of conflict in Europe threatens to become even more complex, we very much need conferences like this that provide for an open and frank exchange of views on what more we can and should do. And I very much look forward to reading the conclusions from your deliberations. But already now, I congratulate Dr. Forde, the Irish Centre for Human Rights, and the National University of Ireland, Galway, for organizing this important event. And I salute the Irish presidency of the Committee of Ministers for its leadership, vision, and determination. I may also add here, that was also mentioned by the Minister of Europe, that it is also highly relevant that the European Convention on Human Rights has played such a very significant part in the Northern Ireland's pathway to peace, in particular through its privileged status in the Good Friday Agreement. Dear friends, yes, a major war is taking place in the midst of Europe. Yes, we have suffered a major setback. And yes, the situation in which we now find ourselves will be demanding difficult, and tough for quite some time. Let us never compromise on the fact that the European Convention on Human Rights remains the ultimate benchmark for protecting human rights in Europe throughout all of our member states, without any exception. And let us never forget that Europe is a source of immense hope, which must not be destroyed by territorial ambitions or the resurgence of aggressive nationalism or the perpetuation of spheres of influence, intolerance, or totalitarian ideologies. With unity, will and determination, and the ability to discuss, negotiate, and work together, we will no doubt succeed in our joint efforts. Thank you very much for your attention.
Thank you very much. Thank you for setting such a comprehensive agenda for the discussions throughout the day. I think there is much that we will be coming back to in the panel discussions and in the follow-on talks. So I hope there'll be opportunities also to discuss further throughout the day. I'm going to move on now to Dr. Andrew Ford, the organizer of today's event. As I said, the energy, the vision behind the event, but also the very hard work that has gone into all of the organization and convening of the event. And bringing us together to address what is a challenging topic, one that raises many challenging questions for us, and at the heart of it, a commitment to trying to strengthen the effectiveness of our systems for the protection of human rights. Dr. Andrew Ford is, as I said, a graduate of the Irish Centre for Human Rights. That's probably one of his most important attributes, but he has many others. He, in fact, completed his doctoral research on the very topic of today's event, which will also be the subject of his forthcoming book with Cambridge University Press. He's worked as a human rights advisor and political advisor with the Council of Europe and the OSCE, and during much of that time focused on human rights protection in post-conflict and conflict regions. And he has extensive experience with working with civil society, national human rights institutions, and public service in different parts of the world and across the Council of Europe. So thank you very much to Andrew, and handing over to you. Thank you.
Professor Mullally, Deputy Secretary General, Senator Curran, Ms. Lamjaria, Ambassador Zurabishvili, Director General Collins, ladies and gentlemen, very good morning to you all. I'm delighted to see you all with us, and you're very welcome to Galway, as has been said already. Your presence is really greatly appreciated, and I would also very much like to welcome those that are joining us online for today's proceedings. Our topic, as has been said, is one of first principles for the Council of Europe, and which for too long has not received the attention that it deserves. The task we set ourselves is to consider how to maximise the effectiveness of the European Convention on Human Rights and Europe's human rights protection architecture in areas experiencing conflict or contestation. We will do so from a system and a standards, if you like, a normative perspective, not a political one. We are not here to relitigate cases or to prejudice ongoing processes. Our interest is exclusively in individual human rights, regardless of where people reside, and the integrity of the world's most advanced regional human rights system. My personal interest stems from having had the privilege of working for the Council of Europe and the OSCE for more than a decade, half of which I spent living and working in Kosovo. Less than a week after I arrived in Kosovo, someone said to me, "Andrew, what are you doing here? We're not party to the ECHR yet. The international community only sees political risk, and they don't really care about human rights of the people of Kosovo." It's something that always stayed with me, Of course, every day we're reminded why this topic is so important. Russia's aggressive and unjustifiable war in Ukraine, in flagrant violation of the Council of Europe Statute, challenges the very basis upon which the Council of Europe and the rules-based international order operates. This is why, of course, the Committee of Ministers so decisively expelled Russia from the Council of Europe in March. Ukraine is not the only case of conflict in Europe, but it certainly is of a scale and intensity not witnessed by many Europeans in living memory. Peace and democratic stability cannot be taken for granted. The fundamental principles of pacta sunt servanda and good faith are being brought into question. And it's not unreasonable now to have concerns about the future of Europe's human rights order. The future of the system, as has been said already, depends on the commitment of the member states and the Council of Europe's statutory organs to have the courage of conviction to articulate a renewed, realistic, and ambitious vision for the future. And I'd suggest that any vision must start with a reflection on the legacy of the past, which is why our discussion today is so timely. My task now is to try to set a broad context for our discussion, and my presentation will focus on three main points. The first is to briefly outline the Council of Europe's practice in relation to these regions. Secondly, I'll explore the effectiveness and consistency challenges facing the Council of Europe. And finally, I will highlight possible areas where maybe the Council of Europe could do more. I will argue that the operational grey zones, which have persisted due to the existence of unresolved conflict, now represent a serious, ongoing and growing risk for the Council of Europe and Europe's human rights protection architecture. Now is the time to engage with this matter in good faith and with convicted, values-based leadership. So turning to the first point, member states of the Council of Europe have pledged, of course, to pursue peace and to collaborate sincerely and effectively for the purpose of safeguarding the ideals and principles upon which are their common heritage, notably through the promotion of human rights, democracy, and the rule of law. Yet there are numerous areas of conflict and contestation right across Europe. In Eastern Europe, Transnistria and occupied parts of Ukraine, the Western Balkans, Kosovo, the South Caucasus, Nagorno-Karabakh, Abkhazia and South Ossetia and the Sing Valley region, the Eastern Mediterranean, Northern Cyprus, and collectively more than 10 million people live in these regions. Indeed, the legacy of conflict endures even on this island, with the effectiveness of the ECHR still relevant in terms of dealing with the past. The affected regions vary widely, and whilst there are some similarities in some cases, no two are identical, and we must avoid conflating them. Historical, social, cultural, legal, and political nuances profoundly influence the reality on the ground, and consequently the opportunities to engage. Kosovo, for instance, is a sui generis case, distinct from all others. It has deeply embedded the European Convention on Human Rights into its domestic legal order, and since 1999 has retained an open pro-European stance, often voluntarily subscribing to Council of Europe standards such as the Istanbul Convention and consenting to ad hoc monitoring arrangements or monitoring-like programs. Its cooperation with the Council of Europe is an interesting example. However, individuals in Kosovo still do not have recourse to the European Court of Human Rights, which is very difficult to countenance in 2022. This amplifies the importance of domestic mechanisms such as the Constitutional Court, especially for minority communities, and we'll hear more about that, I hope, later this afternoon. What all of these regions, including Kosovo, have in common is that Council of Europe monitoring and advisory mechanisms or the control mechanism of the ECHR are unable to function in a fully free, regular, and unrestricted manner, or unable to function at all. This has resulted in millions of people inadvertently falling outside the Council of Europe's sphere of influence. Some describe these areas as temporary technical anomalies within the system of international law, though most of them have existed within a relative international vacuum for anything up to 4 decades, more than half of the lifetime of the Council of Europe itself. Over time, these grey zones have become a normalised exception in the Council of Europe region, with their existence largely accepted as a matter of fact rather than as a problem of first principles, which critically challenges the integrity of the ECHR. Operational blind spots of any kind do not automatically imply rights violations exist, but they do create space for impunity and generate the risk of human rights violations occurring without effective and independent review or access to effective remedies. This risk is sharpest for vulnerable populations, such as those in detention, minority communities, and so on. Rights holders deserve maximum access to and support of the European human rights system. The mere fact that a conflict exists is not a sufficient reason to close the door to engagement. On the contrary, it would of course be wrong to suggest that the Council of Europe has closed the door. It certainly has not, but much more can be done. Council of Europe action in relation to areas of conflict often tends to be seen through the very narrow prism of the European Court of Human Rights. But there is much more to the Council of Europe system than the court. Article 1 of the ECHR requires states to secure to everyone within their jurisdiction the rights and freedoms defined in the Convention. So the ECHR normally applies in the whole territory of states parties to the ECHR, even in areas they do not effectively control. This presumption of jurisdiction is our starting point, though as Dr. Wallace and others will discuss shortly, the Court's Article 1 jurisprudence is riddled with exceptions. Indeed, exceptionalism has almost become the rule. Judge Bonello's general assessment that the Court has been bedeviled by an inability or unwillingness to establish a coherent and axiomatic regime grounded in essential basics and even-handedly applicable across the widest spectrum of jurisdictional controversies may not be particularly flattering to the European Court of Human Rights, but it does seem to bear some validity. And it's for this reason I suggest we look beyond the court for responses to the situation of human rights protection in areas of conflict. Not to ignore it, of course, but to recognize its place and the place of others in the interdependent Council of Europe human rights system. So what has the Council of Europe done thus far? In its decision on securing the long-term effectiveness of the system of the European Convention on Human Rights, the Committee of Ministers noted the challenge of unresolved conflict zones. The first major acknowledgement of the challenge of unresolved conflicts appeared in the 2005 Warsaw Declaration. A year earlier, the Committee of Ministers had noted that the main problem of human rights protections in such situations is not one of the lack of norms, but rather the application or the implementation of those norms. Since 2014 in particular, the COE Secretary General has emphasised the importance of Council of Europe standards in unresolved conflict zones, though there's equally an acknowledgement that efforts taken to date have proven largely ineffective. The Parliamentary Assembly of the Council of Europe issued its first recommendation on areas where the European Convention on Human Rights cannot be implemented almost 20 years ago, in 2003, and it has maintained a watching brief across most of the affected areas since then. Then, in its landmark 2018 resolution on grey zones, the PACE noted the principle of presumed consent in terms of access to affected territories by monitoring mechanisms. The COE operates on the basis of an interdependent trinity of standard setting, monitoring, and cooperation. One does not function without the other. However, monitoring and cooperation activities, when they do operate in the affected regions, tend to be ad hoc and irregular. Any kind of political dialogue, of course, is even less regular. The Committee for the Prevention of Torture, the CPT, has visited many conflict-affected or contested regions over the years. For example, it succeeded in visiting Transnistria on numerous occasions with the consent of the Moldovan government up until 2010, when a visit was interrupted as access was restricted by the de facto authorities in Transnistria. There is no public information available as to what follow-up, if any, has taken place since then. Similarly, the Commissioner for Human Rights, under its unique Resolution 9950 mandate, has visited many conflict-affected areas over the years, some on multiple occasions, including Kosovo, Abkhazia, the Karabakh region, Nagorno-Karabakh, Northern Cyprus, and Transnistria. But again, these visits have been quite ad hoc and highly politically sensitive. Other monitoring mechanisms have had even less success in engaging with grey zones, though some have taken initiatives where they could. For example, in 2021, the European Commission Against Racism and Intolerance, the ECRI, issued a statement for the first time on preventing and combating ultranationalistic and racist hate speech and violence in relation to confrontations and unresolved conflicts in Europe. The COE has shown innovation in other ways too. For instance, in 2004, 2 ad hoc agreements were reached with the UN mission in Kosovo to allow the CPT and the Advisory Committee for the Framework Convention on National Minorities to operate. Then, in 2012, the Secretary-General informed the Committee of Ministers of the intention to engage directly with the Kosovo authorities on the basis of their functional capacity. This allowed for meaningful engagement on Council of Europe standards and paved the way for monitoring-like activities to be carried out, such as Greco, Moneyval, Greta, and others in cooperation with the Kosovo authorities. The Confidence Building Measures Programme has identified areas where parties to a conflict come together on a topic of mutual interest related to human rights. It has operated in Transnistria, Abkhazia, Kosovo, and other areas. Various parts of the system also increasingly work together. For example, we see the court citing commissioner and CPT reports more frequently, so their input facilitates the work of the ECHR. However, there are some initiatives that have been taken that have been less successful, such as the January 2016 visit to Crimea by the Ambassador Gerard Studman, who was tasked with objectively assessing the human rights and rule of law situation in Crimea, which was not without significant challenges. Turning first to the practical impact of conflict and contestation on effectiveness. From those specific areas affected by conflict or contestation, effectiveness challenges have become pervasive in recent years. There has been an increasing tendency for the convention to be challenged or its legitimacy questioned across member states. Delays in ensuring full and timely execution of judgments of the European Court of Human Rights is a major challenge which is undermining the credibility of the convention system. Of the leading cases handed down by the ECHR in the last 10 years, almost half are still awaiting implementation. The Council of Europe also faces the perennial challenge of resourcing, with a growing reliance on extra budgetary resources, which impacts on effectiveness. I observe 3 aspects to the specific challenge of effectiveness of the ECHR in conflict zones. The first is qualifying the problem. The second is determining strategic direction. And the third is exercising what I call the normative will. The statute establishes the Committee of Ministers, the Parliamentary Assembly, and the Secretariat General as the key institutions of the Council of Europe, with other institutions developing by virtue of treaty commitments, such as the Court, or CM resolution, such as the Commissioner for Human Rights. There is, or ought to be, a symbiotic relationship between statutory and non-statutory actors. None function fully autonomously, and only by operating cohesively can effectiveness be maximised. When it comes to the organisation's approach to human rights protection in grey zones, all organs have a role to play. The overemphasis and supremacy of the European Court of Human Rights runs the risk of disempowering other actors in the system. And indeed, the unrealistic expectations on the court also undermines its own legitimacy. I would therefore suggest that when it comes to qualifying the challenge, we should recognise the Council of Europe system as a matrix of mutually reinforcing judicial and non-judicial components for which member states have a collective responsibility rather than a hierarchy of autonomous institutions. Additionally, I think the suggestion that the Council of Europe has no role to play in times of conflict needs to be comprehensively rejected. Territorial conflict is typically treated as a sovereign or bilateral issue. But the protection of human rights everywhere is a legitimate statutory interest of the organisation. Working to improve human rights protection should never be conflated with recognition. It is status neutral in its very essence. The second aspect of the challenge is a strategic one. Although unresolved conflicts have been acknowledged for several years by various actors, follow-up has generally been piecemeal and extremely inconsistent. The 2020 reply by the Committee of Ministers to the Parliamentary Assembly, in which it notes the important roles of the Court, the Secretary-General, the Commissioner for Human Rights, as well as the Council of Europe's monitoring bodies in relation to grey zones, is helpful, but it is insufficient in itself. If the system is to have meaningful impact, we need to move to a place where efforts are prioritised and sustained. The Secretariat has significant expertise, but to translate this into action requires a clearer mandate, or at least the endorsement of the Committee of Ministers. This also would allow for the identification and allocation of the necessary resources. The third part of the challenge is a practical one. What can the COE do in practice to serve as a force for good in regions affected by conflict and contestation? To a large extent, depends on the political support of member states and the resources available to the Council of Europe. But it also relies on the normative will of the Secretariat under the leadership of the Secretary-General and the Deputy Secretary-General. A more consistent focus on this issue is a policy choice, not only a resources one, and can change tomorrow if the desire to do so is there. In human rights discourse, we often refer to the political will of member states. Perhaps we should pay more attention to the normative will of standards-based organisations derived from their founding statutes. Turning to my third point, what then can be done? So what can be done or done better? The first thing to note is that human rights, rule of law, and democracy standards are central, not incidental, to achieving sustainable peace. The Council of Europe's unique arsenal of standards and tools can contribute to all stages of peace building in a status-neutral manner, as it has done on many occasions in the past. It seems to me we need more determination, innovation, and affirmative action. This could begin, as I've mentioned already, with an explicit acknowledgement of the risk of unresolved conflicts to the broader Council of Europe system in a Summit Declaration as a means of establishing the necessary basis for further action. The minimum that can be expected is that Council of Europe bodies and the relevant territorial states cooperate systematically to ensure monitoring mechanisms have full access to relevant territories to the maximum extent within their control. Far be it from undermining territorial states' sovereignty, this would be the ultimate expression of the territorial integrity, sovereignty, and commitment to human rights. Concern for human rights in areas of conflict should not be misrepresented as recognition of legitimacy under international law. This is both incorrect and has a chilling effect on the Council of Europe. The rights holder needs to be the central consideration. The appointment of a special representative of the Secretary-General for areas of unresolved conflict in Europe would allow an authoritative and legitimate direct reporting structure to the Secretary-General and allow dialogue with the Committee of Ministers with a specific standards-based mandate. Drawing on the presumption of consent principle, the Committee of Ministers could consider the practice of examining the issue of access by monitoring mechanisms or routinely debating any limitations on access as cases occur, as has been mentioned by the Deputy Secretary-General this morning. The Steering Committee for Human Rights, the CDDH, and subordinate bodies could be tasked to examine issues associated to the applicability of COE treaties in conflict-affected and contested territories. Council of Europe bodies should also reflect on their own practice and seek to somehow conflict-proof programs in order to explore how they might be deployed more widely and in a status-neutral manner. Some programs are already fit for purpose, such as the COE Help Programme or the Platform for the Protection of Journalists and so on. The Secretary-General could also consider the possibility to replicate the principle of engagement on the basis of functional capacity in other regions. There are convincing statutory and treaty-based reasons to do so. This would potentially allow for monitoring-like processes, such as those that have proven so successful in Kosovo, to potentially be replicated elsewhere. The Confidence Building Measures Programme should be, I think, the Council of Europe's central avenue for cooperation on human rights issues in these regions. The programme could be strengthened by appropriate endorsement of the Committee of Ministers, resourced and extended to explore opportunities in all conflict-affected areas. Whether the programme should come within the direct responsibility of the Secretary-General or the Deputy Secretary-General, or situated perhaps as an operational wing of the Commissioner for Human Rights under the 9950 resolution mandate, are worth considering. But it should come within the human rights programme of the organisation. The Directorate of Programmes has developed extremely useful programming documents, including for the Southern Neighbourhood. Should a similar document be considered for these regions? Member States could also consider building on the Human Rights Trust Fund model to establish a dedicated resource for standards-based work with willing partners in these regions. The PACE too might consider further enhancing its focus on the issues of conflict-affected areas. More generally, there is an opportunity for the Council of Europe, the OSCE and ODIHR in particular, the UN and OHCHR in particular, and the EU to seek to coordinate better and more on these issues. I have not referred to the court, as I leave this to subsequent speakers. However, clearly, there are many questions regarding its practice and reasoning in relation to these regions. This includes looking at the process of the supervision of the execution of judgments. A more proactive, judicious approach is required by all actors to make engagement more coherent, predictable, and ultimately effective. All of this requires the political support of member states and their acceptance of the legitimate interest and role for the Council of Europe in seeking to achieve democratic security, even in regions beyond their effective control. Ladies and gentlemen, to come to the conclusion, Isolation from Europe's human rights system can leave local populations, administrations, and civil society feeling alienated. Areas bereft of engagement are at risk of either turning inward or becoming fertile ground for ethno-nationalism, intolerance, discrimination, or repression of minority communities. The lack of international scrutiny creates ripe conditions for corruption and organised crime to flourish. We also have seen recently how Donetsk and Luhansk have been deliberately misused as a pretext for the unjustifiable invasion of Ukraine. Over time, operational grey zones have become the normalised exception in the Council of Europe region, with their existence largely accepted as a matter of fact, rather than as a problem of first principles, which critically challenges the integrity of the ECHR. In resolving conflicts, human rights must not be left to sequentially follow political solutions. Human rights, democracy, and the rule of law should form the very path to achieving those solutions. I'm inviting you then to consider whether a more judicious approach based on the normative will of the Secretary-General could be pursued. The Council of Europe is not a fair weather vessel designed only for calm waters. It is the bastion of human rights in Europe, whose raison d'etre is to deal with critical human rights challenges facing European society. If it is unable or unwilling to mobilize when it comes to such situations, it risks failing on its central purpose. The words of the former French Prime Minister, Édouard Herriot, on occasion of the establishment of the Council of Europe in the aftermath of a devastating war that raged on our continent and cost so many lives, come to mind. This is an event of cardinal historical importance. Your task is to succeed through the efforts of all in a field where so many half-hearted efforts have failed. Thank you very much indeed.
Thank you very much. As I'm sure you'll all agree, there's no chance that Andrew will allow us to make half-hearted efforts throughout the day. So a lot there for us to continue to work on. I'm conscious that you've been listening to people for a while now. We are going to continue on with our next speaker, and then I'm going to open up for one or two questions before we take a break, and then we'll move into the panel discussion format. So I'm delighted now to welcome Dr. Stuart Wallace, who's Associate Professor at the University of Leeds, where he teaches international human rights law and constitutional law. I should have said delighted to welcome back Dr. Stuart Wallace, who's a graduate both of the University of Nottingham and the Irish Centre for Human Rights, and the author of a book published with Cambridge University Press on the application of the European Convention on Human Rights to military operations. And he's going to talk to us now about the challenges of establishing jurisdiction in times of conflict and transition under the ECHR. Thank you.
Thank you very much, Professor Mullally. As a graduate of this great university and the Irish Centre for Human Rights, I have many fond memories of sitting in the centre, soaked to the skin after another Atlantic deluge, debating the finer points of international law with Ray Murphy and Bill Shabbos and others. So it's wonderful to be back here again to speak to you today. I have the unenviable task of giving an introduction or an overview of how to establish jurisdiction at the European Court of Human Rights, and to stand between you and a coffee break, which is much needed at this point in time. So to begin, I think it's probably helpful if I define what we mean by jurisdiction under the European Convention on Human Rights. And when we think about the term jurisdiction under Article 1 of the European Convention on Human Rights, it refers to securing the rights and freedoms of everyone in the convention to everyone within their jurisdiction. So the term jurisdiction here refers to the jurisdiction of a contracting state. Well, what does that actually mean? When we think of state jurisdiction in practice, we often think of it in territorial terms, that state X is responsible for this piece of land and state Y is responsible for this other bit. And this is mirrored, to an extent, in the eyes of the European Court of Human Rights, who've observed that state jurisdiction is primarily territorial. And when we look at the activities of the state, we should view territory as the medium, the space in which the state exercises its sovereignty and its control. But that's not the limit of the state's capacity to act. It may be primarily territorial, but it is not exclusively so. The world is a very different place compared to when the treaties of Westphalia were signed. The idea of sovereign states existing exclusively within their territorial bubbles, sealed off from one another, was perhaps a little bit fanciful then. But in an age of cyberspace, international organizations, and intercontinental hypersonic missiles, the idea of territory serving as any kind of limitation to state action seems absurd. And as the arms of the state begin to reach increasingly outside of their territory, an important question arises as to whether they leave their obligations behind them in the cold earth. Because against this primarily territorial, dare I say, old-fashioned view of jurisdiction, we must set the idea that human rights are supposed to be different. The Universal Declaration of Human Rights, as the title suggests, proclaims rights to be universal, the equal and inalienable rights of all members of the human family. They should not, in principle at least, only apply within a specific territory. They should transcend territorial limitations applying to everyone, everywhere. And yet, a consequence of protecting rights through international treaties, and in particular the regionalization of human rights protections, is that we end up with imbalances, disparities in human rights protection. And if human rights protections were truly universal, the question of establishing jurisdiction would never actually arise. But in any system of human rights protection that is based on treaties, state consent, and filtered through concepts like jurisdiction, the achievement of universal human rights protection may always be beyond our reach. And that's what makes this subject of jurisdiction at the European Court of Human Rights so troubling for so many different people, because it runs heavily against the fundamental ideas of human rights protection. As soon as we start to question whether jurisdiction can be established for the purposes of the Convention, we implicitly accept that human rights protections are not universal, that there are haves and there are have-nots, and that there is no such thing as a universal human right. We begin to draw arbitrary distinctions between people based on the lines on a map, distinctions which conflict deeply with our sensibilities and our ideas of what human rights are and should be. So with these challenges in mind, let's dig a little bit deeper into this subject by exploring a few key questions. And firstly, before we can really discuss the issue of jurisdiction in times of conflict and transition, we should first consider whether the Convention should apply at all in times of conflict and transition. Because there are many, many people who would claim that it shouldn't. Many people have argued that the law of armed conflict was specifically designed to cover conflicts and that it should take precedence in these situations. That treaties, like the European Convention on Human Rights, have no business applying to conflicts and transitions. You may be aware, for example, that the United Kingdom is currently trying to pass legislation to prevent victims from bringing cases arising from overseas military operations. Indeed, the European Court of Human Rights itself has acknowledged that both the law of armed conflict and the Convention should both be applied in the case of Hassan versus the UK, and more recently, in the case of Georgia versus Russia number 2, determined that the convention should not apply during active hostilities, whatever that means. Of course, arguments that the law of armed conflict should take precedence overlook many inadequacies that exist in that body of law. Many violations of the law of armed conflict go unpunished, and it's an area of law that is characterized by weak enforcement. When violations are addressed, the focus has often been on punishing the perpetrators with criminal sanctions rather than compensating victims or addressing the institutional failings that gave rise to the violations in the first place. Indeed, I've argued in my book that these very deficiencies in the law of armed conflict, they are the driving force behind victims of conflict approaching Strasbourg in the first place. And you can see the appeal for them. The convention system offers obvious benefits over the law of armed conflict in practice. The violations, for the most part, are substantively similar to violations of the law of armed conflict. The convention offers a system of domestic and international forums in which they can raise complaints. It offers clear procedures, a developed jurisprudence, and perhaps crucially, a means of securing compensation for victims and the prospect of institutional reform to prevent the same problems from ever happening again. Which brings us to the other side of the argument, where people claim that states must be bound by their human rights obligations when they engage in military operations. Going back to Giovanni Bonello, the great Maltese judge of the court, who once said that those who export war ought to see the parallel export of the guarantees against the atrocities of war, including the protection of the European Convention on Human Rights. And this speaks to the universalist desire to secure human rights protection, with states required to bring rights with them regardless of where their actions are felt. Of course, the counter-argument here is that the protection and enforcement of human rights laws in the vast majority of cases requires a functioning nation state with institutions like police and courts at its disposal to guarantee human rights. And these preconditions for effective human rights protections are very rarely present during situations of conflict and are often weakened in times of transition, making the protection of human rights in these contexts unworkable. Others argue that the application of the convention to conflicts can compromise the operational effectiveness of troops in the field. And I have argued previously that the application of the convention to military operations in the past has compromised the unity and coherency of the convention's obligations, such as it is. I think the most important lesson that we can draw from these discussions and debates and arguments about whether the convention should apply or not is to perhaps recognize the impossible position that this places the court in. It's where the rubber meets the road in human rights protection, where ideals give way to pragmatism, utopia to apology. And the court is torn between a desire to fulfill its mandate by protecting vulnerable people in dire circumstances, while also trying to avoid imposing impossible burdens on the state to reconcile the interaction between the law of armed conflict and human rights. And the cases emerging from conflict and transition often draw the court into ruling on extremely controversial and sensitive issues, which border on impossible to resolve in a court of law. Can the European Court of Human Rights wave its magic wand and resolve the hundreds of issues in the Turkish Republic of Northern Cyprus? Can it determine the status of Nagorno-Karabakh or the Moldovan Republic of Transnistria? Probably not. And perhaps it shouldn't be expected to either. And yet we still turn to it again and again with these cases. And the fulcrum on which all of these cases hinge is jurisdiction. It's the mediator, the dividing line between the haves and the have-nots. Which leads us to our next key question. How has the European Court of Human Rights handled this huge issue? How has it handled attempts to establish jurisdiction during times of conflict and transition? Unfortunately, the answer to that question is not very well. When I was preparing for this, I thought, if a state asked me for legal advice on whether they were exercising jurisdiction in a given case of conflict or transition, would I be able to give them a clear answer? And I realized I couldn't. I know, shocking. Academic lawyer, fails to give straight answer to question. But it is a serious issue. Despite researching this area of law for almost 13 years now, I do not have any confidence in my ability to answer questions of jurisdiction, because the case law on jurisdiction has given rise to such a variety of qualifying factors to consider that it's almost impossible to know which way the court will rule on a given case. And I started to go through them. Was the state exercising control over people or territory? Does the state claim territory where the incident has occurred as its own? Is it occupied territory? Did the state exercise any public powers there? Did it occur on territory of another Council of Europe state or in a third country? Was it a single isolated incident, or was it a continuing situation? Was it a situation of active hostilities? Was it inside a building or outside a building? Did it occur at a checkpoint? Is the victim alleging a procedural obligation violation or a substantive violation? Was the state serving under an international mandate from an international organization? Did it occur near the state's border? The list goes on, but you get the idea. Each of these factors would alter the court's assessment of whether jurisdiction existed or not. It is a deeply complex, meandering hodgepodge of cases, from Bankovic to Medvedev to Alskany to Pizzari, a torrent of caveats, implicit contradictions, and repeated attempts to clarify the concept of jurisdiction that have, if anything, in truth, only succeeded in further muddying the waters. And if I can't give a clear answer, having literally written the book on it, what hope does a military lawyer in the field have of providing clear advice to commanders on the law, or a soldier responding to a situation in front of them? Now, there are many things that we can do to smooth the process of applying the convention in conflicts and transitions. We can encourage states to derogate from obligations which they can't uphold. We can explore how the law of armed conflict and human rights law can interact with each other and complement each other to improve the circumstances of people during conflicts and transition. And above all, we should explore every avenue of responsibility and accountability that we have for atrocities that occur, including the unjustifiable invasion of another Council of Europe state. But if this brief rundown of jurisdiction tells us anything, it's that we must start to recognize both the benefits and the limitations of human rights courts and human rights law more generally. We must accept that while the convention and the court does have a role to play in these contexts, it cannot be a panacea. And above all, we need to explore the other avenues of conflict resolution that we have available to us, which is exactly what I hope we can do today. And I sincerely look forward to hearing all of your thoughts on this fascinating and complex subject. Thank you very much.
Thank you very much, Stuart. Jurisdiction has been described as the governance of governance, so I think it raises many questions here about how we draw those lines and what are the decisions that go into the drawing of such lines and the politics behind that. I'm going to open up very quickly for one or two questions before we break for coffee, and the incentive for being brief is that you'll get coffee more quickly. So one or two questions. If you wish, if you want to raise your hands and just introduce yourself. Would anyone like to comment, please? Yeah.
Thank you very much. I'm Diana, a representative of the Government Agent's Office before the European Court of Human Rights of Armenia. First of all, I would like to thank for organizing such an important event. My question regards to the jurisdiction. Oh, sorry, thank you. To the jurisdiction issue, I would like to hear some comments about the territorial jurisdiction versus cause and effect test, if possible. This is a big topic, but a few comments, and also about one of the rules of court, Rule 39, there is a paragraph, the second paragraph says that in some cases, the court refers notification to the Committee of Ministers. I would like to hear about the mechanisms. Are there really mechanisms that the Committee of Ministers may implement in such cases? Thank you very much.
I'll see if there's one more question. Another question? No questions. Okay, Stuart, do you want to respond? Yeah, please. Thanks.
I guess. Yeah, very simple questions that you've asked there. Thank you very much for those. I will leave. I think I'll leave the Rule 39 question to Isabella, who's actually going to address that in the later panel. But I can have a crack at the territorial question versus cause and effect jurisdiction. I think the primary dividing line that we tend to see there in terms of territorial control is that the court doesn't find territorial control unless the state is exercising control over another part of a Council of Europe state. So we only really see that idea of spatial jurisdiction, the Loazidu line of cases, for example, arising where a Council of Europe state invades and controls another area of state. With the cause and effect jurisdiction, that has been the subject of many challenging cases. I mean, the most recent example that we see of that, I suppose, is or the most, I guess, high-profile example is probably the Al-Skeini case. And in that context, I argue that the court kind of blurs the lines over the distinction between territorial jurisdiction and cause and effect jurisdiction. So you need to have some kind of control over the territory, exercise some kind of public powers there before the cause and effect jurisdiction arises. But to be honest, we've seen lots and lots of different cases where the court has also said, yeah, there might be cause and effect jurisdiction here too, but I'm not really sure. But yeah, that's it. Unfortunately, I can't give a more definitive answer than that.
Thank you. So with that, not so definitive answer, but with much food for thought and for discussion, thank you to our speakers this morning. Particularly thank you to the Deputy Secretary General, to Andrew and Stuart. We have a quick coffee break, 10 minutes, and then we'll resume for our first panel discussion. Thank you.
To move now into our first panel discussion, which is going to be, I think, an extremely interesting discussion related to the broad range of challenges facing the European Convention on Human Rights in areas of conflict and contestation. It's a great pleasure for me to introduce today's panel discussion, which will be moderated by Professor Siobhan Mullally, who you know well and have already seen. And welcoming on stage also, we have Professor Bashak Chali to my far left. Bashak is a professor of international human rights law at the Hertie School and co-director of the school's Centre for Fundamental Rights. She's a renowned expert in international law and institutions, international human rights law and policy. She's authored publications on theories of international law and the relationship between international law and domestic law standards, standards of review in international law, interpretation of human rights law, legitimacy of human rights courts, the implementation of human rights judgments. She's the chair of the European Implementation Network and a fellow of the Human Rights Centre at the University of Essex. Basak, you're very welcome. To Basak's right and to my left is Dr. Isabella Ricini. And Isabella is not only a good friend, but also she is an expert in international human rights law. She studied law at the University of Augsburg and the Chicago-Kent College of Law. During her qualification period for the German bar in the Higher Regional Court District of Munich, she completed a stage at the headquarters of the German Foreign Office in Berlin. Subsequently, she also had the opportunity of a traineeship at the European Court of Human Rights. Her PhD thesis was on the area of interstate applications under the European Convention between collective enforcement of human rights and international dispute settlement. It was published in 2018. And last, but certainly not least, we have Professor Philip Leach. And Professor Leach, many of you will also know, is a very well-established international expert in human rights. Until March 2022, he was director of the European Human Rights Advocacy Centre, also based at Middlesex University, which litigates human rights cases arising from in Russia, Ukraine, Georgia, Azerbaijan, and Armenia. He researches and publishes widely in the field of international human rights law and practice, and he's the author of several books and publications in relation to human rights. So without further ado, I'll hand the floor over to Siobhan Mullally to take us forward. You're very welcome. Thank you.
Thank you very much, Andrew. So we're moving into a panel discussion format, and I'll be asking each of the panelists one or two questions, and hopefully we'll have time also to open up to you for comment. So I'm going to kick off asking Philip about the perspective of litigation, the challenges that arise in litigating cases related to areas of conflict at the European Court of Human Rights and in seeking to engage the jurisdiction and reach of the convention itself. What are the very specific challenges that arise, and what have been your experiences, and how it may be possible or not possible to overcome those challenges, and how, importantly, how they impact upon the protection or lack of protection of human rights.
Thank you very much, Siobhan. I just check that you can hear me. I think you can okay. Yeah. Well, thank you very much, Siobhan. These first comments are with my ERAC hat on. As Andrew mentioned, until recently I was director of the European Human Rights Advocacy Centre, litigating with national NGOs cases from Russia and Ukraine, Armenia, Azerbaijan and Georgia. And of course, a number of there are contested territories in those countries, and a number of the cases have concerned South Ossetia and Abkhazia, of course, Eastern Ukraine and Crimea, and Nagorno-Karabakh. And we've litigated with national NGOs, with Memorial in Russia, with the Georgian Young Lawyers Association in Georgia, with Ukrainian Helsinki Human Rights Union and Ukrainian Legal Advisory Group, and many others, in fact. A number of cases in relation to contested territories. And I just wanted to really make the point that they do raise particular challenges. I think and I just wanted to mention some of those. The first is the question of domestic remedies, and the need, the starting point, of course, is that you have to exhaust domestic remedies in every case, and that can prove really challenging. I mean, there's no exception, as we know from the Demopoulos and Cyprus case, that it is necessary in some instances to utilize remedies across territories. But that creates real problems where there is a question about not only the application of the international law we've been talking about, but also the very question about which domestic law is applicable. We have situations, some of the situations of occupation, like Russia in Crimea, ostensibly imposing its own domestic law on the territory in which it's occupation of. So the question of domestic remedies is often very difficult in Strasbourg cases, as everyone will be aware. It's doubly difficult in the context of contested territories. There are real practical difficulties too of getting access to applicants and witnesses. real questions of safety and security for those people. We certainly have seen that in eastern Ukraine and Crimea since 2014. But real practical problems of getting access, so you can get instructions, so you can get documents, and so on. Allied to that is the whole question of evidence gathering in this context. Andrew was talking earlier about the importance of monitoring mechanisms having access to these territories. I think it's also very important to establish the principle of the starting point, at least, of the court also having access. Of course, it's not going to be possible all the time. It raises real feasibility and security questions, but the court has a very important fact-finding function. We saw it in the Kurdish cases in southeast Turkey in the 90s. It's used much less now, but I'm a great supporter of it. I think it's where the court needs to do that work, it needs to do it. And so I think we need to come back to looking at the question of fact-finding. I think with that, we also have new mechanisms through open source evidence now, new mechanisms that international courts and domestic courts need to get grips with and get hold of. One example from our practice is, again, from eastern Ukraine, our NGO ERAC commissioning forensic architecture, who many of you will know, to investigate and analyze evidence of Russian military presence in and around Ilovaisk in August 2014. There's a case that's pending in Strasbourg on that. And in addition to the sort of usual documentary and witness evidence that was submitted, we submitted a database of this evidence obtained through sort of machine learning, technical stuff I don't pretend to understand, but remarkable stuff it's all available on the ERAC website now if you're interested. And that is before the court. The case is pending, so we don't know. It'll be very interesting to see how the court will use that. But real questions of evidence. One of the most fundamental questions is, of course, the legal challenge to establish responsibility, as a number of people have already mentioned, the question of both attribution and of jurisdiction. And they are, of course, separate questions, looking at the role of the territorial state, the state with effective control, the role of the de facto authorities. And maybe I can just also make a point here about jurisdiction in conflict that Stuart so wonderfully outlined. And this comes back to the question from our Armenian colleague about direct effect. I think the Georgia-Russia judgment, in which the court said that there is no jurisdiction, extraterritorial jurisdiction in active phase of hostilities, as Stuart mentioned, I think is very regrettable. It's part of the sort of mix and the mess that we've had from the court that Stuart outlined. And I do think we need to respond to your question. I do think we need to move towards more of a direct effect test. You can look at the Human Rights Committee, look at the General Comment on Right to Life, General Comment 36 from 2018, that has much more has gone that way. And I think also from the court's own jurisprudence, you can if you look at it very, very carefully, I think you can see a combination of factors about immediacy, proximity, foreseeability that I think are factors that ought to outline a test so that there are no black holes, as I think there's no legal vacuum, as Siobhan and a number of other people have said. But that's certainly a fundamental issue that I don't think has been, with all due respect, helped by the Georgia-Russia judgment on jurisdiction. I think, perhaps lastly on this, Siobhan, I can just talk about more practical issues of delay and timing and so on. One of the problems, I think, is that the interstate cases are given precedence by the court, which I don't think need necessarily be the case. So the individual cases sit for many, many years behind the interstate cases, and of course they raise the same legal and similar factual questions. It seems to me that the court ought to be prioritizing both the interstate cases and a selection of the individual cases. The other thing I would say, I've certainly seen some pleadings from states that it would worry me very, very significantly if the court were to make its decisions based on some of the state pleadings that I've seen. They're often highly politicized, is just one of the problems. I'll leave it there, long answer to your question, Siobhan.
Okay, thank you. I think we'll come back to that point, and I think it raises an interesting question around that prioritisation and what is the rationale for that and what are the consequences of that in terms of access to the courts and to effective remedies, but also perhaps to the jurisprudence of the court as well, whether it has that impact. I'm going to move on to Isabella to introduce us a little to some of the challenges that arise around substantive limitations on jurisdiction, particularly with regard to international humanitarian law, interstate cases, and perhaps also interim measures. Isabella.
Thank you very much. Thank you very much for the kind introduction, and I'm very honored to be speaking here today in this panel and in this presence. I'm going to offer some reflections on the interstate application and come back to some of the questions that we've heard and also reflect on jurisdiction. I will do so also against the background of the Georgia versus Russia case that is the background to many, I think, interventions today, and I would also concur it was not very helpful. However, I would like to also reflect whether this criticism that we've heard is going up the right tree. So I have already said I'm studying interstate applications, which I deem personally very fit for the purpose of looking into situations of conflict. I think this is exactly what it is sort of meant to look at areas of conflict where, as we have already heard, where human rights are endangered the most. So I think it is very worthwhile to continue to have this mechanism, and also we've had both the honor and the duty to assist with a reflection process within the CDDH on interstate applications. I think it is important to keep this. I've found this reform and reflection process a little bit like sitting in a Formula One car with a handbrake on. So I've been speaking with the chair, Alain Chablais, who is here today too, and said it's a normal process. However, I would sort of hope that many of the limitations that you alluded to will not sort of then impede the use of this mechanism, and this is a point I'd like to really make. The use of this mechanism should sort of not be impeded. On the contrary, I would like to sort of underline what is going on at the moment. So we have an ongoing war in Ukraine, and we have the 10th case between Ukraine and Russia, and we have very little, I must say, engagement with this mechanism that is so fit for this purpose by the member states. So notable exceptions are the Netherlands, who have first as a third party, then as a party joined some of the proceedings, and also Latvia has now recently joined proceedings as a third party, while it could have also been a party. And the other member states seem not to deem this necessary to join this case, while at the same time they are standing in line at the ICJ to intervene in the case based on the Genocide Convention that confers probably a much more narrow chunk of jurisdiction to the ICJ. So if one wants to effectively apply human rights law, the convention in these areas of conflict, which I think it should be done, then I would find it very useful if courts would if member states would send the message to the court that they want the courts to apply the convention in exactly these areas of conflict. And now, which brings me to interim measures, and also maybe ask in response to the question, there's a project, an interesting project by Rosana Garcendia and Jean-Pierre Fauci under BICL that deals with confidentiality. So I'll speak otherwise you come up if I haven't answered this completely. But so what has happened with these interim measures? So since about 2008, upon the request of individuals and states, broad interim measures were issued by the court concerning Article 2 and Article 3 of the Convention. So these proceedings are mostly confidential. So the court gives notice of these interim measures via press releases, so we don't have actual documents. And unfortunately, the court has not sort of used the occasion of Georgia versus Russia #2, where also such an interim measure was in place, to explain a bit further how the mechanics of these interim measures work. So what influence these have. So the court requests from the parties and reminds the parties of their existing legal obligations. So it does not add new obligations. It refers to existing legal obligations, both under human rights law and humanitarian law, and requests from the parties information on how the measures are implemented. And I've ascribed to these interim measures a certain supervisory deterrent effect, which I cannot prove, of course, and which I just hope. And today, Konstantin Zesou, who cannot be here today, would have probably offered a more critical take on interim measures. So I think that it is important for the court to say something in the context of such conflicts. And I would also like to underline that the states, especially affected by conflicts, go to the court and request these measures, request that the court applies these measures. So they probably intend that the convention applies to such a conflict. This is how one could interpret the state practice, that the states especially affected want the convention to be applied in this context. And we have also seen now recently so-called, what I say, are counter applications. So both by the applicant states and by the respondent states. So even more an evidence of the fact that the convention should be applied, at least in the eyes of those who are especially affected by conflict. So I think states could probably provide a stronger legal basis also for this, but this is maybe more wishful thinking. And I'm gonna conclude because I think time is running. So I'd like to concur a lot with what Dr. Stuart Wallace has said before. So on the idea of jurisdiction and how it should be applied in the context of acute conflict. And I also would sort of here underline again, and this might be really an old-fashioned view, so to see what states want. So if the states would express more clearly what they want here, this would probably be very helpful for the court to get a little bit of a clear idea of how Article 1 and also Article 2 then should be applied in such contexts. And I think it shouldn't be left alone to the court as a matter of pure interpretation of a jurisdictional clause to square the circle. So this would be my conclusion here so far.
Okay, thank you very much. That raises interesting questions, I think, around the role of the court or the potential role for states in determining questions of or in seeking to determine or influence questions of jurisdiction. The question there around interstate applications, the queue forming at the International Court of Justice, but lesser use at the European Court of Human Rights, and why is that so? And the questions around interim measures. Your suggestion, Isabella, that you are finding a deterrent effect, that these are potentially useful measures, important for those affected by rights violations. But there may be other more critical perspectives on that also. So I'm going to move on now to Bashak Chali to talk to us a little bit, to just reflect around questions around remedies, access to effective remedies. So critically important in terms of vindication of the protection of rights. So,
thank you. I hope you can hear me well, and thank you for this. So This is a really challenging thing because I could just make, one very short observation in saying that, there are not that many remedies that are delivered by the court and the execution is not looking that good, right? I mean, this is something I think this distinguished panelists will all agree as to the big picture. But I'd like to do something a little different because that's something that I think we would all, look at the HUDOC exec website and everything, we would find out about these challenges. So I just like to maybe do three things. And it's how I thought about it. One is to kind of set a little bit of the context of the remedial challenges. So not look at remedial challenges in individual cases, but like the bigger context that really poses some major challenges in the Council of Europe. And then talk about how the court deals with these challenges. And then maybe just look at some of the issues around execution, but not talking about political will, right? I mean, that's not what I'm going to talk about. So what are the things we could productively think as to the institution's current practices and things? So the point about the context is we all go back to the drafting history of this convention. It has been mentioned today. I'm sure it will be mentioned many, many times. Also, the Statute of the Council of Europe, its preamble talks about peace, based upon justice and international cooperation, so that there's this sort of a looming kind of an idea, obviously in the drafting history of the statute and the convention about peace and justice and human rights. But of course, the institutional history of the Council of Europe, including its court, was not about that. This is not a court about dealing with human rights in conflict situations. That's not exactly, even though we made references to Ireland, the Irish cases and the lawless, but that's not how the court has evolved historically. I don't want to undermine the lawless and the Irish references here. And the convention's mechanisms, not the court, just the court, the Committee of Ministers, all of the other organs don't really deal with conflict, peacekeeping, peace building, conflict resolution. This is really not the turf of the Council of Europe. So I think it's institutionally quite weak. We were mentioned a couple of ideas here, but I think, compared to others. And of course, the statute 1 paragraph, subparagraph 3 says, of course, states can work under the UN and all other organizations, and you could say, well, that's the UN's job, or that's the OSCE's job, but not the Council of Europe. But the third, perhaps, point about context is that you can't just say Article 1.3 of the statute, because the conflict has arrived to the Council of Europe through individual and interstate cases. So it's impossible to kind of say, this is not the right institution to deal with conflict, because the interstate cases and the individual cases have brought it to us. And I think that's where we are, and I think that's why we need to think about the lack of the work or sort of outsourcing to the UN, the Minsk process, the OSCE, and so on, and whether these ideas are there now that we have a massive amount of cases which don't seem to end before the Committee of Ministers or before the court. But of course, the remedial question is a big challenge because we've never thought about the remedies. What are the red lines of remedies in particular? So what are the things that definitely should be subject to political negotiation and settlement and mutual sort of understanding? And what are the red lines on remedies that states should not be able to negotiate on what is the appropriate remedy for enforced disappearances, for accountability, for lots of other issues, right? So there's a big gap in actually a remedial culture in the context of conflict in the Council of Europe. And I think this is reflected in the court's practice. The court stays away from individual or general remedies. It doesn't instruct, right, under Article 46, and it emphasizes over and over again, this is the role of the states to negotiate certain outcomes. It's the role of the Committee of Ministers to supervise. And one area that it has actually been sort of the most significantly contributing was Article 46 and just satisfaction claims in these cases, but not in other types of remedies. So the court, I think, when we read its case law, is saying, I don't want to develop these standards. I don't think I'm the right place to develop standards on remedies. This is someone else's job. but here's some just satisfaction, and this is through just satisfaction hearings and so on. Even though there are a few things, maybe we can think of the Xenides Aristis case, where there's some indication of what we may call procedural institutional remedies. Please set up a commission. Please set up some institutions to deal with conflict claims in these jurisdictions. I don't see this, and we can discuss it, I don't see it as a big pattern across all the cases. So there seems to be kind of here and there type of issues. So the court is unable to fill this gap of what are the remedies that are red line remedies versus political negotiation remedies. I think this is how I read the court's case law here, which means a lot of things are in the hands of the Committee of Ministers. So the Committee of Ministers is the place where everything is supposed to happen according to the court's current practice, minus just satisfaction. And you guys all know about the just satisfactions issue. And I think what we need as academics, or what maybe we can contribute to the debate, is why there is such resistance across the board to just satisfaction in these cases, why this is so threatening, and what I think somebody called it this morning, this confidence building measures was mentioned a couple of times. What could we do as the institution to actually sort of isolate this resistance to payments of just satisfaction? So what are the measures? And obviously these are not legal measures, I understand. They have to be other types of measures. But perhaps finally on the Committee of Ministers, and I think this is where this conference can be quite meaningful in the light of quite a lot of new reforms that are coming up, is that the Committee of Ministers, I don't think its current processes are not really fit for doing the big work that it's thrown at it by the court, saying, please look at the remedies, decide if they're effective and so on, because this type of work cannot be done through paper work. Action reports, Rule 1 submission, Rule 9.2, this is the standard work of the Committee of Ministers monitoring. Whereas in this type of remedial situations, I think on the ground, knowledge of effectiveness of what's happening is very, very important. And because these are highly political issues, either you have responses saying, we've done everything, we're amazing, and then the counterparty saying, this is horrible, they've done nothing. And this is what the Committee of Ministers is getting as data. And this data is just not the way to work this process. So I think the Committee of Ministers will really need to think a bit more creatively to move beyond this paper shuffling paradigm on execution. So I'll end there.
Thank you very much. And I think it follows through, so I'm going to return to Philip to ask a little bit more about the questions that arise around the Committee of Ministers, and specifically also to talk about the Nagorno-Karabakh experience and to comment on those themes in that context.
Sure, it follows on very well from what Bashak said. I mean, many people will be aware of the two Grand Chamber judgments from 2015 dealing with Karabakh, one against Azerbaijan and one against Armenia. I was involved in one of them, but I'm talking about both of them. And I think we have a lot of lessons to learn. So those judgments 2015, they've been subject to the Committee of Ministers supervision process for 7 years. The cases, very briefly, were both about victims of conflict on both sides, people who were driven away from their homes and their land at the time of conflict and have never been able to return. So the European Court found violations of the right to property, and the right to home and so on, and continuing violations. One of the things that the Grand Chamber said in both judgments, and the Grand Chamber was very, very assiduous in dealing with both cases sort of in the same process, in the same way, showing even-handedness. One of the, I think, very important things that the court said was that it underlined the necessity to establish a property claims sort of restitution process, property mechanism for the IDPs and the refugees who'd lost their land and their homes on both sides. It was clearly set out in the judgment. The court's very clear to say, despite the ongoing peace negotiations, that doesn't absolve the states from having a responsibility to move on and create some kind of mechanism. What's happened in 7 years is, it's very hard to describe what's happened in 7 years in any tangible way. So it's a real, I think, a real failure. There is a legal obligation on both states to comply. There is also a legal obligation on the Committee of Ministers to supervise the implementation of these judgments. I would say that neither state has produced anything that could be seriously called a proper action report or an action plan, sorry, for restitution. So we have a failure. We have more than a million people who were the victims on both sides, refugees and IDPs of that conflict, who have never had any kind of justice. These cases have been sitting there for 7 years. We must do better, it seems to me. We talked about the importance of individual rights. Well, here's a very good concrete example. I don't know why there isn't more measures haven't been taken. I mean, of course, there is an ongoing conflict there. One diplomat told me a few years ago it's just too difficult. Well, I don't think for me, that's not enough. That's not the right response. I think what Andrew's initiative in establishing this conference, I think, underlines is the need for a much more of a serious focus on these kind of cases. So we have the Council of Europe, through these cases now, I'm just giving you one example, has the remit to take action. The OSCE Minsk process over many, many years has not produced tangible results. The Council of Europe needs to move now and take over or get involved seriously in that space and see what can be done. So there needs to be a strategy of implementation, combining the work of the different Council of Europe bodies that a number of you have mentioned. I don't see that at all. I see nothing. And just going back to Russia, if I may just briefly, Siobhan, I think there's a link here. For what we see in Ukraine, we've seen Russia to some extent doing this to its own people for 20 years ago in Chechnya. And my colleagues at Deraka Memorial have been talking to diplomats for a little bit less than that about the Chechen cases. There are several hundred cases. And there is often a lot of interest from diplomats, and every 2 or 3 years they move on. But there is nothing like any kind of coherent strategy or plan to get those cases implemented. Now, I'm not saying it's easy, but there's the absence of any kind of coherent plan over time is regrettable, and I think we now need to learn some of these lessons. I'll leave it there. Thanks, Siobhan.
Okay, thank you. And I think that also raises returns to the comments made by Başak around the role of the Council of Europe or its relative weakness in terms of engaging with questions of peace and security and the mechanisms and processes to do that, and how we think about doing that and what are the different steps, processes, methods, institutional possibilities available now. We heard this morning about the high-level reflection group, the possibility of a fourth summit, and what might that mean for those questions. I'm going to come back to Isabella just specifically on Georgia and Russia too, and you might just comment more specifically then on what were the drawbacks or not of engaging there with the use of interim measures in that context.
Mm-hmm. So I come back to Georgia versus Russia, and maybe I say first what was done and what was then not done. So it was what the court did. It was established Russia's responsibility for the consequences of, at the time, the gravest military confrontation that the continent had seen up to then, and it sort of established also violations of Article 2 on the procedural leg. It did not want to exercise its jurisdiction over the days of acute conflict, and this caused a lot of academic discontent, I would say this. And this discontent maybe comes from something that blends in with what also Başak said. So we have implementation problems in international law, so we are all aware of this, and human rights lawyers especially are aware of it. But for better or for worse, the convention system is probably the best implementation mechanism that we have in place in Europe overall, maybe also in the world. So I think that discontent needs to be also reflected where it comes from. So it is also the absence of other mechanisms that work to a sort of decent level of success, other initiatives that have not produced any tangible results. And also international humanitarian law, if I may add, is not a body of law that is very apt for implementation. It's rather something that is out there and creates, on my side at least, rather frustration for non-implementation. So, and some people have pointed out now that the broad use of interim measures is rather hard to reconcile with now the idea that we see the court not exercising its jurisdiction where there is chaos, to use the word of the court. Now, this criticism, I think it is placed, but I'd like to sort of say here, it is one thing to remind parties of a conflict of their existing legal obligations, both under international humanitarian law and human rights law. And it's another question whether the court sees itself in a good position to pass judgment and assign responsibility to one or two or both parties, and which has also to do something that Philip said earlier. So we also need the court to be equipped to do this rather sort of insurmountable almost task. So this is also a question of can the court deal with larger conflicts that we now see, unfortunately, in Ukraine that are not limited to 4 or 5 days, but are now already, we are already in the 6th month. So it's also a question of resources. And therefore, I'd like to try to reconcile. It is good to hear the voice of the court in the context of acute conflict, to expect the court to then assign responsibility in difficult contexts with not many resources and with, if I may add, all other challenges also sitting on its docket, is maybe something that is a bit much to expect from the court, and therefore I see the member states also in their duties to direct and equip the court with the necessary means, both on legal and factual resource-based strata to do its work, to fulfill its task.
Thank you. So I'm going to come back finally then to Basha, and maybe to take up that theme, because I think it touches precisely on what you were introducing us to earlier as well, around our expectations for the court, and what can or should we expect of the court, and what might be the court's role or should not be its role in the context of conflict, protracted conflict, and the ongoing problem that you already mentioned around execution of judgments, which we're all very familiar with, but what might otherwise be done in relation to that, or how should we be trying to think differently about that if we're thinking about the future of the Council of Europe, the role of the ECHR. We cannot continue to just go around in circles, wringing our hands, if you like, around the problems in relation to execution of judgment. So what other things might we think about?
Yeah, and I think we're not unfamiliar with state parties communicating their expectations from the court, right? So this is not something that has not happened. The Brighton Declaration was a form of a communication, maybe Protocol 15 was another communication. So there has been moments over the years. Brussels Declaration, I think, was a good one. That's passed now. Anyway, you're familiar with this kind of processes. And of course, I think this is one area where the court, I would imagine, looking at especially its remedial challenges of what to say, what not to say, how far to go, how far not to go, because obviously if it goes too far, it could face more backlash from the states. If it doesn't say anything, it fails victims of human rights violations in context of conflicts, right? It's a very difficult, I think, position. So this kind of communication of expectations by the state parties, through a declaration, through the summit or through other things, I think would be very helpful, because then the court could sort of have a better clear understanding of, especially here I'm talking about remedies, right? The remedial approaches, whether the court stays declaratory and leaving it all to the states and the Committee of Ministers, or whether it's able to be a little bit more standard setting in terms of remedies in conflict situations. The court has some standards in other areas. So I think this is indeed possible, and I think this is a helpful way to think, rather than to say, oh, the court hasn't, done enough. I think that seems to me not a very healthy way of maybe thinking about some of the remedial approaches in these cases. But where do we learn from? So that's another big issue. Obviously, UN is a place the court has, for example, referred to Pinheiro principles. Obviously, these are some very important work. So a lot of conflict and human rights related standard setting has also happened elsewhere and not necessarily within Council of Europe. So there's another question also, whether the Council of Europe should have its own standards. So there are actually, recommendations, guidelines from the Committee of Ministers, which is there, which we know the court is comfortable in using, right? Because that's the acquis of the Council, or whether the court should be instructed to study the UN principles, the guidance from the Pinheiros and others. So there are some interesting questions about also how we want the court to do more, and in what way, so that it doesn't face a legitimacy or authority backlash for doing more than what it should have done in these areas. So I would really think that's a good area to think.
Thank you. And so I'm going to open it up briefly to questions, comments on any of those themes, but particularly thinking about the questions around effectiveness, litigation challenges, the challenges of ensuring remedies. What should the court's role be? What could it be? And if you wouldn't mind just introducing yourself quickly. Bronya, please.
Good morning, everybody. Good morning, everybody, and thank you so much for all of your comments. I'm finding this event particularly fascinating. It's giving certainly me much to think about and reflect upon, which will continue, I hope, after the conference ends. But I'm a senior counsel in Ireland, and I've just also been one of the Irish representatives on the Venice Commission for the last 8 years. I continue in a role as an expert advisor to them, and I'm currently a rapporteur for Ukraine. I'd been assisting President Zelensky and his government draft a law restricting the illegal activities of oligarchs. And clearly this was a mission that was not completed before the invasion by the Russian Federation. But I think the problems you've identified in perhaps lacuna in the law and jurisdiction of the European Court. This is talked about in many arenas within Europe. And I note that the Parliamentary Assembly passed a resolution, and I think I even have the text of it here, which I'll share with you, because I think it's very important and very pertinent to the current discussion. Sorry, of course I've thrown my glasses to the wind. Sorry. The Parliamentary Assembly refers to its resolution in 2022, stressing the need to ensure accountability for war crimes, crimes against humanity, and possible genocide, as well as the crime of aggression in connection with the Russian war of aggression against Ukraine. And the Assembly invites the Committee of Ministers to both strengthen the competent services of the Council of Europe in order to enable them to provide assistance and advice to Ukraine and those member states exercising their universal jurisdiction with investigating and documenting gross human rights violations. Now, it also encourages all member states, and this is perhaps the most important thing, to participate in setting up an ad hoc international criminal tribunal to prosecute the crime of aggression specifically. allegedly committed in this context by the political leaders and military commanders of the Russian Federation against Ukraine by way of a multilateral treaty between like-minded states, and to examine the ways and means for the Council of Europe as a whole to play an active role in setting this up and operating such a tribunal, including by providing logistical or other technical assistance. So I think there is a perceived difficulty in dealing with specifically the crimes of aggression. And the problem is that with somewhat narrow terms of reference and jurisdictional parameters, there is often a sense of perhaps almost dysfunction, an inability to take matters forward. So I think there probably is a need for such a tribunal to be set up. Something Dr. Rossini also commented upon that I was really interested in, perhaps because I'm personally involved at the moment, in trying to persuade member states to file an intervention as amicus to the proceedings that Ukraine has in the European Court of Human Rights. Because I think this is meaningful. I think it's very important. It is a way in which member states can actually, and not just member states, individuals, NGOs can file an intervention as an amicus. I am very hopeful that Ireland will file. I'm very sad that they were pipped at the post, despite my best endeavours, by the Netherlands and by Germany, and there are a number of other countries. But I think it would be particularly meaningful for Ireland in its presidency of the Council of Europe right now to get in there and file. And God knows we have adequate locus standi. You know, we have 50,000 Ukrainian refugees in this country. And I'd be very anxious that perhaps amongst the audience there are those who can influence their own countries, their own organizations, to just file an intervention, join the proceedings, step up, please. Thank you.
Thank you, Gráinne. I'm going to see, are there one or two more questions before I go back to the panel? Shane at the back there. At the back, please. Thanks.
Thank you. Shane Darcy from the Irish Centre for Human Rights. My question sort of follows on a little from that, and it's for Professor Leach. What do you think is the prospects of the European Court following the Human Rights Committee's understanding of jurisdiction in General Comment 36, but also the related novel idea that any deprivation of life arising in the context of an act of aggression amounts to a violation of the right to life, given that the areas of conflict in Europe, not least Ukraine, is a context of aggression? Thank you.
Thanks, Shane. And we have one more question just up here. It's the top. Thank you.
I'm Harry Hummel. I work in the CURE campaign to uphold rights in Europe, an NGO initiative to advocate for stronger and more effective Council of Europe. The situation in zones of conflict of the people who live there is one of our priority areas. Two questions. One is on the Nagorno-Karabakh example. You know, in my view, in this case, we, civil society, academics, parliamentarians that are concerned should have lobbied their own governments to take a stronger role in the Committee of Ministers to kind of, well, you know, put more pressure on these two governments to follow up on the judgment. A next step could have been, and this would be something new, also where I hope, you know, academics and legal experts could play a role, would be to, you know, start a civil suit against the Armenian and Azerbaijani governments by a number of victims, backed up by the judgment of the European Court of Human Rights, and then see whether there, you know, is a possibility to claim this money directly, if it is about money, you know, and part of it is about money that should be paid in reparations. Second question, I think that in the discussion until now, it is important to make a distinction between the situation in conflict zones that relate to, you know, a conflict between where one of the states is Council of Europe member and the other state is not. This is the new situation when it comes to conflicts between Russia and Georgia, Russia and Ukraine. And it is a fundamentally different situation, I think, when you talk about two Council of Europe member states that are involved in the conflict. In this situation, I see a lot of there is a Ukrainian NGO calling for, the massive submission of claims to the European Court of Human Rights for destruction of property. Will there be by Russian invaders? Is there any prospect of, this is the Ukrainian Helsinki Foundation for Human Rights, so, Helsinki Union for Human Rights, so it is a reputed NGO. Is there any prospect of the court, judging about this? Well, they have said they will, and at least when it concerns, events until the 16th of September. And then is there any prospect of the Committee of Ministers, really putting pressure on Russia, which will be presumably, the state that has to pay reparations? Is there, and how could this work? And again, my idea would be, is there any merit in foreseeing the submission of, civil claims against the Russian state in this case? Well, this would be a further future. The first step would be for existing Council of Europe member states to, maybe take steps themselves, impound Russian state assets, backed up again by an International Human Rights Court judgment.
Thank you very much. I'm going to go back to the panel to conclude, and then we'll have a time for further discussion in the afternoon and over the break. So, Philip, do you want to kick off?
Sure, yeah. More easy questions, thanks very much. They're fantastic questions. I'll try and be brief to the extent that I can answer. Gronya, crime of aggression, my view, there's a clear gap in about prosecuting crime of aggression. There needs to be a body that can do that, given that the ICC in this particular context can't do it. Whether there's of course a debate about whether it should be an ad hoc body or could it be established through the auspices of the Council of Europe. It may be something that the high level may be taken to the fourth summit. I think in one way or another, my view is that it should happen. We need to make it happen in one. I'm not sure whether it matters how it's done, but we need to make it happen. I think it's very important for you to raise that. And generally, your point about you had a point about state activities involving interstate actions and MICUS and so on. And I think again, another lesson to learn is the reluctance of states to use we have these mechanisms. We've had the interstate mechanism for many, many years. It seems to have woken up in very recent years. But what we also need, I think, is the sort of policing aspect of that to be woken up. Where was the interstate case over Chechnya 20 years ago, for example? One can give lots of other examples. Why didn't that happen? That should have happened. And perhaps we learn the lessons from the failure to do that. I'm not saying for a moment the European Court would solve all these problems. Of course, that's the last thing I'd say, but of course, I do think it has an important contribution. So now is the moment to learn again from the invasion what could have been done. Shane, very briefly, prospects of the court moving towards more of a direct causation. I think it may be more likely with the Human Rights Committee at the moment. But again, I think different judges have different views. And I think, if I think back 10, 15 years ago, I'm not sure the judges sitting then would have made the Georgia-Russia active phase of hostilities decision. Different judges have different views on this. I think you can detect from the court, from the boundary, the Solomon Andrew cases and so on in Northern Cyprus and other cases, elements of the factors that I mentioned about direct causation, foreseeability and proximity. So I think you can see elements of that, but it is, as Stuart says, quite a jumble. So I think immediate prospects, given Georgia-Russia, I don't think are very good, I would say, regrettably. Harry, on Nagorno-Karabakh, Again, as I was trying to, we needed a strategy from 2015, and so we absolutely do need civil society to be lobbying governments. There's no pressure on the Committee of Ministers, it seems to me, to individual members of the Committee of Ministers to sort of have any to make any progress in relation to something like that. There's just where's the pressure, where's the leverage? So I think we need to think about that. I think Mary Robbins is absolutely right to talk about sort of raising the profile, bring the ministers in. We need ministers and senior officials there and also answering questions, and in some cases doing so publicly, I would say. I will leave it there because there's a lot to cover.
Yeah. I would also concur largely. Other courts, I think especially aggression is a problematic gap. I think that some ad hoc tribunals have been very successful with similar issues, but I would also sort of underline that it is good to use existing mechanisms that are in place and are apt, maybe not dealing with aggression and having also their limitations, but having already those, the machinery that we already have, and this is already quite sophisticated, that it is being used by the member states, and I think also followed up on by the member states on also a high level. I think that would be already a very useful sort of exercise. And maybe also to the question about Russia and what are the prospects there. I think the immediate prospects are sort of really bad. And I've had the honor and the possibility to attend a conference on 50 years of the Greek case, which is, I don't want to equate this, but it is a case that has certain similarities. And so in 50 years from now, I think we should all be able to look into each other's faces and say, okay, the machinery responded correctly at this time, and sort of also see this rather historic perspective. This is now not satisfactory for those who are suffering right now, I understand this, but I think it is also this bigger picture that we should take into account, that we respond now, we document what happened, we write it down, we have it sort of all clear who did what. I think this is a very important function of this mechanism. It's also about just satisfaction, of course, but I think now the main thing that can be done now is to document and to record what happened. And
Asha?
It's a lovely, lovely panel. I'm in large agreement with my panelists, so there's not huge amounts to add. But maybe just three sort of repetition is good, right? We like repetitive cases, repetitive statements. I think we also need to understand, in particular in relation to execution, different mechanisms of resistance. So we know that things are not working. I've given the example of just satisfaction, regardless of which country you pick. There's only one country who's paid a big amount and many others haven't, and so on and so forth. I mean, we see that there's a pattern. It's not just about one country. So we have to understand, what is it that actually lead to these outcomes? So I think this is an area we have to also understand, because we have to think about mechanisms of resistance to execution to work on execution. There's no other way about that. And I think the know-how and standards, clearly, I think this is an area that maybe it's the moment, as Phil and also Isabella were saying, this is when we have to rethink about what is the real know-how here. We like to talk about our court. We like to talk about our case law. We know things, and we all think we do know a lot of things about conflict and human rights, but maybe not. So I think this is also a good place to maybe come out of the court's jurisprudential box, or however we talk. This is the Council of Europe language, right, with the court. And I think leverage. So I'm all with Mary Robinson and with Phil and others about having ministers in meetings and really bringing a lot more political presence to the work of the Council of Europe in all these fields more generally. But thank you so much for the panel.
Thank you very much. So bringing politics back into lawmaking, and I think you also raised the question earlier, Bashak, about looking to the UN system, looking at whether the Council of Europe can learn from the UN or vice versa, or other regional systems, and specifically in relation to conflict situations, that there may be much to learn looking elsewhere, moving outside of that box, and reflecting back also. So hopefully those are questions that we can take up again throughout the day and inform the discussion. So I'm going to have to conclude. Thank you very much to all of our panelists for a really rich discussion. And I hope we can return to some of those themes throughout the day. And I'm going to hand over now to Andrew for the next session. Thanks.
So sincere thanks to Bashak, Isabella, Philip, and of course Siobhan for that really rich discussion. Clear call to action, I think, to member states in terms of meeting and taking some of these issues forward. And in fairness, I think that is the momentum we're starting to see in terms of the discussions around the fourth summit. But we still have to get the ministers in the room. So, okay, thanks very much. Before I introduce our next distinguished speaker, just a humanitarian issue I want to deal with. Toilets. There's, just so in case there's a rush after the break or at the break, to say there's one that people will have probably found, which is just out that door upstairs and sort of over our heads. That's one option. But there's also another, if you just go out the door you came in and over to the right-hand corner of the quadrangle, there's another door there and there are toilets there also. So, and there will be more coffee cups in the afternoon. So they're the humanitarian issues sorted. So without further ado, it's really a great pleasure now. I'll thank you again actually to the panelists for your very interesting discussion, first of all. So without further ado, there's been a lot of discussion this morning in reference to the role of the Parliamentary Assembly of the Council of Europe and the important role it plays both as a deliberative mechanism but also as something of a catalyst for standards. So it's my pleasure to introduce Mr. Claude Cairn, who is Parliamentary Assembly President of the Subcommittee on Conflicts in Council of Europe area to discuss the role of the Parliamentary Assembly of the Council of Europe in relation to conflicts. Mr. Cairn he's the Vice President of the European Affairs Committee and member of the Culture, Education, Sport, Communications Committee. He's also Chairman of the France-Hungary Country Group and Vice President of the French delegation to the COE as PACE, as I've said. He's part of the ALDE Group and President of the Subcommittee on Conflicts. Additionally, he's a member of the Committee on Honouring of Obligations and Commitments of Member States of the Council of Europe and the Committee on Political Affairs and Democracy, which are, as you will all know, extremely important committees within the Council of Europe structure. So, without further ado, Mr. Cairn, you're most welcome to take the floor.
Thank you. Ladies and gentlemen, Excellencies, first, I want to apologize for my bad English, but you know the difficulty for the frog eaters, mangeurs de grenouilles. On behalf of the President of the Parliamentary Assembly, Tinny Cox, I would like to thank you for having invited the Assembly to outline its views on its role, or better, to say its specific opportunities and challenges with regard to conflicts inside the Council of Europe geographical area. Parliamentary diplomacy is a key component of the work of the Parliamentary Assembly, in which, over the years, it has obtained considerable experience. From the honest, it has deployed this parliamentary diplomacy towards the conflicts within our geographical area. Initially on an ad hoc basis, mainly through the activities of the Monitoring Committee as well as the Political Affairs Committee, and lately on a more structural and institutionalized basis through the Subcommittee on Conflicts Concerning Council of Europe member states, of which I'm the chair since 6 years. The Monitoring Committee, which is tasked to monitor the membership obligations of all Council of Europe member states, has an important role to play as, for the Assembly, conflicts should be approached foremost from the context of upholding each member's obligations to respect international law, protect human rights, and resolve their differences peacefully. It is important to stress that the Assembly does not see itself as a conflict resolution mechanism for the conflicts in our area. Also, we would not shy away if we would be called upon to fulfill such a role. But we foremost see ourselves as a mechanism to support and strengthen the work of the official mediation mechanisms by providing a platform for parliamentarians of conflicting to meet and together with their peers from our other countries be able to meet, talk and reflect on possible solutions to the conflicts and their consequences on its citizens. That last reflection brings me to a key point for our approach. Many of the conflicts we face have been with us for a long time and solutions not easily foreseeable. At the same time, the people in the conflict areas, citizens of Council of Europe member states, are suffering and their rights violated. Attempts and efforts to address and to relieve their suffering should not be put on a hold until a conflict has finally been resolved and a lasting peace declared. While our efforts in that respect should fully adhere to respect the fundamental principles of international law, including with regard to the inviolability of international borders, relieving suffering and protecting human rights of our citizens should not become hostage to the impossibility to resolve the conflicts in question. This is valid to the citizens in the conflict zones under the control of the government, to which they de jure concern, but also those living in so-called gray areas, the areas that are not under the control of the de jure authorities. The areas this conference is focusing upon. Addressing the needs and protecting the rights of citizens in those areas comes with a unique set of challenges as a result of the unquestionable need of respecting international law and principles in all our actions at all times. In Resolution 2240 on unlimited access to member states, including grey zones, by Council of Europe and United Nations human rights monitoring bodies, the Assembly considered that the activities of human rights monitoring bodies with respect to these grey zones, including their contacts with the de facto authorities and visits to the territories in question, do not constitute and should not be present as recognition of those authorities' legitimacy under international law. However, this is not one-sided or unilateral. This recognizes both the need for unlimited access to these territories by human rights monitoring bodies, as well as the fact such access is preconditional on the acceptance by all parties to the conflict that such activities and contacts cannot be interpreted or seen as an explicit or implicit recognition of any legitimacy of the de facto authorities. However, from the work of the Assembly, it is clear that it is possible to develop connect activities and actions on that basis. Representatives of the Turkish Cypriot community regularly participate in Assembly activities that concern them, without conferring any legitimacy to them under international law. Similarly, in the framework of the monitoring procedure for the Republic of Moldova, the rapporteurs have had regular access to the Moldovan region of Transnistria, which has resulted in the elaboration of a set of activities in the framework of my subcommittee with regard to the Transnistrian settlement process. This subcommittee was established in 2015 by the Monitoring Committee. It is composed of representatives from Armenia, Azerbaijan, Cyprus, Georgia, the Republic of Moldova, Turkey, and Ukraine that are party to conflicts, and their respective monitoring rapporteurs. The subcommittee should explore how the Assembly, through its monitoring committee, can support the work of the existing conflict resolution mechanisms that have been established for the conflicts in question. Our activities are undertaken in full agreement with the authorities of the member state concerned and can address a wide spectrum of issues relevant to human rights protection. They are also carried out in full compliance with international law. Again, our activities and contacts by no means imply any recognition of the de facto authorities. Under these conditions, the subcommittee was able to launch a series of activities. Coming back to the Transnistrian conflict settlement, as a result of the contacts established since 2018 with all stakeholders from both riverbanks and the OSCE, the subcommittee will organize in the future a seminar on the Council of Europe contribution to promoting human rights in the Transnistrian region of the Republic of Moldova, to discuss and promote the protection of human rights in Transnistria through the implementation of the recommendations of the CPT, the execution of the Strasbourg Court rulings, and the promotion of confidence-building measures. Our subcommittee will continue to follow the developments related to the Nagorno-Karabakh conflict and to explore in more details concrete mechanisms that could lead to reconciliation, the establishment of genuine peace, and the protection of cultural heritage. In other areas, we have been less successful. Despite the considerable attention given by the Assembly to the consequences of the war between Russia and Georgia, and indeed initial contacts and even access to the Georgian region of South Ossetia on a status-neutral basis and with the agreement from all concerned. Further actions and access proved impossible to realize, mostly as a result of the linking by the Russian Federation of such access and contacts with the recognition of the legitimacy of the de facto authorities and the creeping annexion of these regions by the Russian Federation. Following the invasion of Ukraine by the Russian Federation, it was soon clear that these would lead to Russia's expulsion from the organization and no longer be directly covered by the monitoring committee. This has resulted in the subcommittee exploring different possibilities to address the conflicts concerning Ukraine and Georgia. This process is currently taking place. In the case of the ongoing war in Ukraine, it should, of course, be emphasized parliamentary diplomacy